everyone, and welcome to this session. I am happy that after a long gap, I am now again in touch with the Judicial Academy and some of the provisions of the law. And I would like to thank the Director Sir and Additional Director Madam also for remembering me once again in this institution. This is the one of the institution where I am always associated with, and I have worked here with everyone in this academy. Before we begin, I think most of you know me, but let me introduce myself first, because it's always better to know everyone here and the resource persons before we begin our session. So, my name is Suraj Chettri. I think all the officers present in Gangtok, everybody knows me. Maybe some of the officers who have come all the way from the districts, they may not have seen me, or we may not have the opportunity of meeting each other. So, I am in this profession for quite some time. It's been 27 years I am in this profession. I was a lawyer, then I became a judicial officer, and now I am a secretary, legal Remembrancer-cum-Secretary. I don't know how much I can remember, because remembrancer means you have to remember each and every law, but I am trying my level best. And legal Remembrancer-cum-Secretary for the past almost 5 years. So, to talk about today's session, I have a small PowerPoint presentation, so where I have tried to, in short, incorporate all the provisions which are beneficial for the executive magistrates. Everyone, and welcome to this session. I am happy that after a long gap, I am now again in touch with the Judicial Academy and some of the provisions of the law. And I would like to thank the Director Sir and Additional Director Madam also for remembering me once again in this institution. This is the one of the institution where I am always associated with, and I have worked here with everyone in this academy. Before we begin, I think most of you know me, but let me introduce myself first, because it's always better to know everyone here and the resource persons before we begin our session. So, my name is Suraj Chettri. I think all the officers present in Gangtok, everybody knows me. Maybe some of the officers who have come all the way from the districts, they may not have seen me, or we may not have the opportunity of meeting each other. So, I am in this profession for quite some time. It's been 27 years I am in this profession. I was a lawyer, then I became a judicial officer, and now I am a secretary, legal Remembrancer-cum-Secretary. I don't know how much I can remember, because remembrancer means you have to remember each and every law, but I am trying my level best. And legal Remembrancer-cum-Secretary for the past almost 5 years. So, to talk about today's session, I have a small PowerPoint presentation, so where I have tried to, in short, incorporate all the provisions which are beneficial for the executive magistrates. Let us first start with the definition, because this is very important. Who are magistrates? I was going through my books, CRPC and other books also. There is no specific definition of a magistrate. Who is a magistrate? It's not defined in the book, especially in CRPC or BNSS, Bharatiya Nagarik Suraksha Sanhita. But magistrate, but we can say that magistrates are appointed offences within limited jurisdiction. The word magistrate comes from Latin word magistrus, which means administrator. This is what I got. Now, if you see, there are different kind of magistrates. First, judicial magistrate of first class. I was appointed as a judicial magistrate of first class. And there are judicial magistrate of second class also. Although we don't have in Sikkim, but in other states you will find a judicial magistrate of second class also. Now, what is the difference? Its only difference is the powers that the magistrate can exercise. Judicial magistrate of first class has little bit more power than the judicial magistrate of second class with regard to the imposing penalty, fines, etc. Otherwise, everything is same. Now, after first class, second class magistrate, then comes the executive magistrates. Every magistrate has his own territorial jurisdiction within which he has to function. Like all the magistrates know, you have your territorial jurisdiction. You cannot go beyond that jurisdiction and pass some orders. Like judicial magistrate also, we have our territorial jurisdiction. If I am a judicial magistrate Gangtok, then my territory will be within Gangtok only. I cannot call for a case from Namchi and dispose it off. That cases, I am not talking about appeals. I am talking about trials. Because there is a difference between appeal and trial. Highest court to decide criminal cases is the Court of Sessions. In Sikkim we have district and session judge. One person holding two different posts actually. In other states you have two different persons. One discharging the function of sessions judge and other discharging the function of district judge, because there are a lot of cases in other states and a single person may not be able to justify both in civil and criminal division. Now thereafter comes the chief judicial magistrate and additional chief judicial magistrates. Then comes the judicial magistrate first class, then comes judicial magistrate second class. This is the hierarchy of the courts. Now, why I am saying this? Because most of the people think that chief judicial magistrate is above the session judge because of the word chief judicial. Actually, he is not above the session judge. In a district, session judge is the most powerful judicial officer who can impose a penalty of death also. That is his powers. Whereas chief judicial magistrate has the power to impose the penalty up to 7 years only. 7 years only. So now comes the every magistrate is subordinate to sessions court. Judicial magistrate are subordinate to chief judicial magistrate. This is just refresher only. Nothing to do with your powers and functions. Now comes the executive magistrates. This is important. In every district, the state government shall appoint as many persons as it think fit to be the executive magistrate and appoint one of them to be the district magistrate. You all know. You have been working as a magistrate for quite some time, so this is the hierarchy which you follow in every district. So state government may appoint additional district magistrate, ADMs. Then state government may also confer powers of the executive magistrate to commissioner of the police. In Sikkim we don't have that practice, but in some other states they have. Even the commissioner, we don't have a commissioner of police only in Sikkim. Now, special executive magistrate. If you see section 15 of the BNSS, there is a provision which says that government can appoint a special executive magistrate. Now, he shall be appointed for particular area and to perform a particular function only. So, this is important, because if you are appointed as a magistrate, executive magistrate for all purpose, then you can discharge all the functions as a magistrate. But if you are appointed only for a specific purpose, like, let me give you an example. Like, you have been, recently there is a notification where the magistrate have been given the duty to, not the magistrate, the MEOs, BDOs and all, they have been given the duty to be the magistrate when search and seizure is to be performed in drugs cases. So if a particular magistrate is appointed under section 15 of the BNSS, and if he have been given the powers only to perform a particular function, then he cannot perform other functions, because his powers are limited to that, parameters only, whatever is given to him by the state government, not beyond. If you are appointed as an executive magistrate to do something, you can only perform that many functions as notified by the state government, not more than that. If you start, functioning in other manners, and if you start disposing of the cases or taking up other issues, then that will be beyond your jurisdiction, and if we say it in legal parlance, that is outside the jurisdiction and ultra vires, we can say, beyond the law. Now, subordination of executive magistrates, section 17 of the BNSS. Every executive magistrate is subordinate to DM. District magistrate is the head in the district. Every executive magistrate is subordinate to DM. DM may from time to time make rules or give special orders consistent with this Sanhita, that means BNSS, as to distribution or allocation of the business among executive magistrates. So I don't know whether this has been done in our districts, but the Sanhita gives the district magistrate this power. He can give orders, he can make rules, he can distribute the business, what business to be conducted by which magistrate, that DM can decide. Now the functions exercisable by a magistrate are broadly been defined under section 3, subsection 2 of the BNSS. This is a broad definition. Judicial magistrate exercise function like inquiry or trial, committal of cases for trial, appreciation of evidence, imposition of penalty or punishment, order for detention during inquiry or trial. This is the broad function of the judicial magistrate. Now, up to trial, I think there is no problem, there is no confusion. Committal of cases, what is this? Committal of cases means Chief Judicial Magistrate is it's like a junction. All the charge sheets are being filed in the court of the Chief Judicial Magistrate. Chief Judicial Magistrate will take the cognizance of the offence, means he will go through the charge sheet, peruse the provisions of law. Then if the cases are triable by higher court like sessions court, then he will commit that case, transfer that case to the sessions court. If that some of the cases are trial by first class magistrate, then he will transfer those cases to the court of first class magistrate. So all the charge sheet in the judicial system are being filed before the court of Chief Judicial Magistrate. And appreciation of evidence, imposition of penalty, that is there. That is also there for the executive magistrates also. So executive magistrate exercise powers and functions which are executive in nature, and like granting, suspension or cancellation of license, prosecution sanction, withdrawal from prosecution, etc. and power conferred under BNSS. So this prosecution sanction also, if you see the CRPC, this BNSS, actually the DMs are directly involved in all those prosecution matters also. Because if appeal has to be filed, then it has to come through the DM actually. If PP has to be appointed, it has to come through the DM only. So these are broad functions. Now apart from above, in Sikkim, executive magistrate performs following function also. This is what I got after much of research, because I am not in touch with all these things nowadays. I am an administrator kind of person nowadays. Granting of COI, registration of deeds, public premises eviction authority, then Sikkim Public Demand Recovery Authority, then marriage registration under Hindu Marriage Act, and to rule to provide for registration and solemnization of forms of marriage in Sikkim and Special Marriage Act also. These are few of the acts which are already enforced in the state of Sikkim also. Like this rule to provide for registration of forms of marriage, 1963, this is our old rule. This is a Return and Maintenance Act, Hindu Guardianship Act, Hindu Succession Act, all those acts are not extended, only this Hindu Marriage Act is extended in the state of Sikkim. Now, one more function is given to the executive magistrate, that is the Tribunal under the Maintenance and Welfare of Parents and Senior Citizens Act 2007. Now, I don't know, any of you have heard about this Cultivator Protection Act. This act is also there in the state of Sikkim. I remember this because long time back, I think that time, the one who is now in deputation in Government of India, he was the DC Gangtok. No, long time back, I think it is in 2000 or 2009. I conducted one case before the district DM Gangtok regarding under this Cultivators Protection Act. One Pradhan from Siche was there. He was my client, so I conducted this. That's why I remember this. Now, this is there. Now, these are also few of the functions which have been given to you. Swearing an affidavit under section 333 BNSS. This is whenever any affidavit has to be filed before any court, like even if before the Supreme Court, High Courts or District Courts, then it can be affirmed in your presence. How you will affirm? You have to personally call the deponent before you. He has to sign in your presence, then only you can sign. At the bottom, you have that solemnly affirm and confirm before me by this person on this date in presence of this witness, then you will authenticate it. Do not sign any of these affidavits without the presence of the deponent, the executant, because that might put you in trouble later on. Because sometimes what happens, in a good faith you will sign it. If that person dies, they are as already dead the other day, then because this kind of instances has happened. I have dealt with one case where, I don't want to name the person, somebody has signed at that particular point of time when he signed that affidavit, that person was admitted in Gangaram, Delhi, the deponent, and that affidavit was executed here in India. And that was challenged before the court. I did not pass any order against the person who authenticated that affidavit, but that was a challenge before the court. The lawyer was strongly harping on that, how he could do this. There has to be a strong action against him. So do not sign any affidavits without the presence of the executant. We call it a deponent. Always ask the deponent to be present before you sign affidavits. Now, OBC certificate, income certificate, property certificate, employment certificate, unmarried certificate, birth and death verification. There are so on and so forth, so many functions given to you all. Now, this chapter deals with the powers of the executive magistrate under BNSS. This is important. There are a lot of powers given to you. Lot of powers. If you say chapter 9, section 126 to 142, purely these are the sections you all can exercise powers of this. 126. This is all the sections are under BNSS because now the numbering has changed. Numbering has changed. If you see the CRPC, 107 onwards, yes. But if you have the book, if you have a CRPC book with you, then you can just see this. At the front, after the contents, you can see this table, this kind of table. In this table, the provisions of the CRPC is also given and the corresponding provisions of BNSS is also mentioned. So you can just, if you remember 144, because we used to call 144, now what is 144? Actually 144 is one of the powers given to the executive magistrates. Now if you look for 144 here in this BNSS, you will not find it. Now it has become now 163 or 162. 163. So you can just refer to this table so that it will be easy for you to see which section is now corresponding, which section of CRPC corresponds to which new section of the BNSS. Because book is very, very important. The reading of this book is also very important. If you don't have this book, please, you can just, make a requisition, or you can directly buy it also from these vendors, because this book is of this professional book publishers. One fellow comes from Allahabad. I have his contact number also, because when I was a lawyer, I used to buy a lot of books from him. You can buy one book. Now this is 126. If a magistrate receives information regarding likely breach of peace and tranquility by any person, he can order for succors to such person as to why he should not order to execute a bond or bail bond for keeping peace for a period not exceeding 1 year. So this is in our, the common term, this is called as binding down. Binding down. Bind down. This is bind down. You all do, especially before election. Lot of bind down took place this time also. So this is the provision. Actually, you can call someone if you have the information or if you have any kind of report saying that this person might create nuisance. You can call that person, ask him to execute the bond, but only for 1 year. You cannot execute a bond for more than 1 year. Your powers are limited for 1 year only. You can ask him to execute a bond, that too with sureties. You have to ask that person, come, you have to be present before me, you have to execute the bond, and you have to bring the sureties also. What sureties will do? Sureties will execute a bond saying that I am responsible for this person's deed. If he does something wrong, I will be responsible. I will come, I will bring him before you, and I will make sure that you will not commit such things, such nuisance. And you have to fix certain amount in the bond, like 5,000, 10,000, 20,000, depending upon the nature and seriousness of the offense, or the nature and seriousness of the incident that might be committed by this person in future. Now 127, if a magistrate receives information regarding illegal publication and dissemination of any content, defamatory content against a judge, or that is anyone makes, sales, import, export, distributes or publicly exhibits or puts in circulation obscene matters, magistrate can order for sober as to why a bond for good behavior should not be executed for a period of 1 year. This can also be done. If somebody is, circulating something which should not have been circulated in the community, then you have the power to call that person. But there is a rider which says that such order cannot be made against a publisher, editor or printer who has published the content in conformity with Press and Registration of Books Act. There is an act called Press and Registration of Books Act. If that content is permitted by this act, then you cannot bind it. But if that contents are not permitted by this act and those contents are defamatory contents, those contents are contents which should not have been circulated in the general public, then you have the powers to bind these kind of persons also. 128. If information is there stating that the person is concealing himself to commit cognizable offence, the magistrate can order for so cause as to why a bond for good behavior. It's also the same. Concealing himself, that means he is a kind of habitual offender and he is concealing within your jurisdiction. Then also if you have information, if you don't have information also, if you have any personal knowledge, or you can send some police officers to inquire, and if the report comes that yes, he has a certain kind of criminal background, he should be brought before the magistrate and he should be fined out. Then you can pass these orders also. Section 29. If information is there that a person is an habitual offender, a robber, housebreaker, thief, forger, there are so many offences. Almost entire IPC is there in this. Most of the sections in the IPC are there. And housebreaker, in the habit of receiving stolen property, this is also punishable offence. If somebody is receiving the stolen property, then that is also an offence. You cannot say that I didn't know that this is a stolen property. If you have purchased or if you have received the stolen property and later on if it is proved that the property was a stolen one, then the person who has received the stolen property, he will also go to jail along with the thief. Habitually harbors thief or aid in concealing stolen property, habitually commits or attempt to commit kidnapping, abduction, extortion, etc., etc. Magistrate can order for so cause as to why a bond of good behavior should not be executed for a period of 1 year. So in this also you can execute a bond. You can bind him down. Section 130 provides that a so cause order should be made in writing containing the substance of the information received, amount of the bond to be executed and the term of the bond with number of sureties. You just cannot, say that he should appear before me and I will bind you down. No, because you have to pass an order and that order has to be a speaking order. Now what is in a speaking order? Speaking order means it has to be in the manner stated in 130. That means how the information was received, what was the information, and why it is necessary for you to bind him down. That reasoning has to be there. You just cannot write 2 lines saying that I have got the information, brought him before me and asked to execute the bond. No, you have to justify your action. What happens if you do not justify? Maybe if nobody challenges it, nothing will happen. But if somebody goes to higher form, then that might be an inappropriate order, irregular order, or in some cases, illegal also. So try to justify your action. You can just write 2 lines saying that he has the criminal history of this. So now, upon my investigation and inquiry, I found that this person is now still involved in this kind of activities. So it is proper, you can just, add 2-3 lines in the interest of justice and to maintain tranquility, peace, order in the society. I am binding him down. I think this will do. Now another is 31, 32, 33, 34. So if such person is present, order should be read over and explained. When you think that somebody is a notorious character and he has to be brought before the magistrate and asked to execute a bond, then when you call that person, he will appear before you. But there are instances where he may not be able to be present before you. If you see the second line, if such person is present, order should be read over. Once he comes before you, then you have to read over the order you have passed. Why you have asked him to appear before you. You have to read over the order. Even in court we do that. We call that a hearing on charge. When an accused comes before the court, we read over the charge to him. That means you have been charged with these kind of sections, what you have to see. You want to confess it, you want to plead guilty, or you want to contest the case. So that kind of hearing opportunity should also be given in these kind of cases. If not present, he should be summoned, and if in custody, should be produced. So if he voluntarily comes, well and good, you can read over. If he is not appearing, you can summon him, even you can issue the warrants also. And if he is in custody, then you have to issue a production warrant to the jailer. That such person needs to be produced before me. He is already involved in this kind of cases and he is in prison. So please produce him on such a date at this time before me, before the court of such and such magistrate. You have to issue that production order. Through the police, it will go to the prison. Prison will produce him before you. Then you have to again do all these procedures, reading over and whatever you want to do. If arrest is necessary to prevent breach of peace, warrant of arrest can also be issued. This is a huge power given to the magistrates. Warrant of arrest. You can issue warrants also. Now, section 135. Magistrate to inquire regarding truthfulness of such information received. Now, this is a kind of procedure to be followed by you while dealing with this kind of cases. You have to inquire regarding the truthfulness of such information. If there is an information that Mr. X is involved in certain kind of offences and he is a very notorious character, that is an information only. So, to substantiate that information, you have to make an inquiry. You have to inquire. You can send someone, you can send a police, or you can send some of your subordinate officers also to inquire into the matter. Once inquiry is done, then you will see whether that information was truthful or not. Documents and witnesses to be examined for ascertaining the truth. You can examine the document, you can examine the witnesses. Maybe what kind of document a notorious character will have. What kind of document you will examine? Maybe you can examine the document like FIR, police report, FIR, even if he has already been convicted in some of the cases, then the judgment of the court. So these are the documents which will give you the information that Mr. X is actually a notorious character. After ascertaining truth, if magistrate considers that for prevention of breach of peace or for prevention of commission of any offence and for reason to be recorded, order such person to execute the bond or detain him in custody until conclusion of the trial. So after you ascertain everything, when after inquiry, after examining the documents, everything, after doing everything, when you are sure that this person is a notorious character or he needs to be brought before the magistrates for and ask him to execute the bond, then you will pass a final order and ask him to execute the bond with sureties. Even without sureties also it can be done, but it is always good to have sureties. Even the provision also says that there has to be one or more sureties when you are binding down someone. However, such inquiry should be completed within 6 months. So if you are making the inquiry, then inquiry has to be completed within 6 months. You cannot go beyond 6 months while doing the inquiry. Either you have to bind him down within 6 months, completing the inquiry within 6 months, or you have to release him back. If not concluded, inquiry shall stand terminated after the expiry of 6 months, and if such person is in custody, proceedings against him shall stand terminated upon expiry of 6 months. So beyond 6 months, this cannot go. Whatever you need to do, you have to do within 6 months. Complete everything in 6 months and ask him to execute upon. But if it goes beyond, if it is in custody also, if you have asked, if he is really a notorious character and you have sent him to custody for some time during the pendency of the inquiry, then also that if you have not completed the inquiry within 6 months, then you will be released after that. 136. If proved upon such inquiry that for keeping peace and maintain good behavior, such person should execute a bond, magistrate will confirm his order and make further order accordingly. Now this will be your final order. Because there will be stages in passing orders. When an information comes, maybe you will pass one small order saying that this kind of inquiry has been received, so I need further investigation in the matter to confirm the truth. That could be your first order. Then when you or your subordinate officer or the police is making the inquiry, if once he submits the inquiry report, then you may have to pass another order saying that this kind of report has been submitted. Then you may issue the summon warrant or production warrant against such person. Then once everything is completed, then you will confirm your order. You will pass a final order whether you want to bind him down or not. Bond shall be fixed considering the circumstances and may not be excessive. This is also there in the provision only. This is not from my pocket. It is there in the book. So if he is a petty kind of miscreant, then you cannot ask him to execute a bond of 10 lakh rupees. That will be excessive. Maybe 50,000 bond will be enough for him. But if somebody is a big fish, then you have to fix the bond amount accordingly, as per the facts and circumstances of the case and the gravity of the offence. In case of child, only surety shall execute the bond. Lot of mistakes are being done in this actually. A child is not supposed to sign anything because he is not capable of signing any document. So if a child, because nowadays the child of 8-9 years also, they are very mischievous. I have seen, I have dealt with this kind of child. You don't believe, a child of 8 years old child was abusing Gaza for almost, more than a year. This is the scenario in Sikkim. We will deal with those provisions also, NDPS and SADA, in the next session. And if the child has to be bind down, then only the surety for the child will sign or execute the bond, not the child himself. You must be having that format of the surety bond in your offices. In courts, we have that format only. You don't have to write everything. Only you have to enter the name and the bond amount and date only. everything is it's in a template form, a printed form. So in that, there will be two kind of contents. One is for the miscreant who has to sign, and at the bottom of that same paper, you will have bond to be signed by the surety. So these kind of forms are available. So in that, in case of child only, the surety, that means the lower part of the bond will be executed, not the upper part. Upper part you just score it off. 137. If it is not proved upon such inquiry that for keeping peace and maintaining good behavior, such person should execute a bond, magistrate may discharge him, and if in custody, release him. There is nothing to discuss in this. This is a very clear provision. Now, another provision. There are few provisions which I thought that it is not very useful for you all after this, because this is 37 now. I am jumping to 40. Let me just give you the gist of those provisions also. 138, 139. 138 is order to give surety. 137 is discharge of the person informed against, because I have dealt with all those provisions, so I am not specifically dealing it section by section. So I am directly, now 38 is commencement of period for which surety is required, contents of the bond, up to this 137 up to 139. I have not included in the PPTs, but I suggest that you should read these provisions also. Content of the bond. What will be the content of the bond? That is also given in that provision. Now 140. Magistrate has power to reject surety produced by such person or surety previously produced by such person. Now, in a case, all the formalities have been completed, you have conducted the inquiry, everything is done, and now you are passing the order that Mr. X should execute a bond with sureties. And if he brings a surety having a more criminal record than him, then what you will do? Will you accept that? No, you will not accept it, because you have the powers, you can reject. So you will ask him to produce someone with better character. Even in the court we do the same. We don't accept the surety of such person who does not have proper documents. Because what is the duty of the surety? Duty of the surety is to take responsibility of this miscarriage. And if surety himself is a greater miscreant than him, then tomorrow both of them will, run away. They will vanish in thin air. So always ask some good person to be the surety. Ask him to bring someone having proper documents. You cannot say that you have to bring a person with good character to be the surety. Maybe that will be too much. But if you have a doubt, then you can reject that surety and ask him to bring another surety. Or you can ask him that bring one more surety. Surety के ऊपर एक और surety. Magistrate shall hold such inquiry before rejecting surety. Now this is the procedure. You just can't reject. You have to hold inquiry. Why you are rejecting? What are the reasons? You will have to find it out. Then only you have to reject it. Notice to be given to the surety and the person before holding inquiry. Now, notice to be given to the surety. Surety word has already come here. Why? Because this is the case where, in a case, a magistrate has already accepted surety. He has already bind him down and accept surety. But later on, if the magistrate comes with certain facts that the surety is not proper, then in those old cases also you can ask him to change the surety or bring a new surety. You will reject that surety also. That is why this third line, notice to be given surety. So, if you are rejecting that surety, then you have to give notice to that surety also. I am rejecting your surety. If you have anything to say, you appear before me on this date and put up your submission. And even you have to give notice to the miscreant also. Because I have mentioned such person, I don't want to mention that word miscreant, because it may not be proper. But you have to issue notice to the miscreant also. Why? Your surety should not be rejected. So after inquiry, if surety is found unfit, may reject such surety with reasons. Reason is everywhere, and it is important that you have to give reasons before you pass any orders. Do not pass any orders without reasons, because that is what will be challenged later on. This is a blanket order without reasons, so this will not sustain. And the higher courts will, in most of the cases, they will set aside this kind of orders if the orders are without reasons. I know there are instances where it will be difficult to give reasons. I have also faced a lot of difficulties giving reasons, but always try to give reason. Maybe it's a flimsy one also, but give some reasons, so that later on the higher court might not say that this order is without reason. Now 142, magistrate can release any such person imprisoned who failed to give surety. If all the process is completed, you want to bind him down, but he is not bringing the surety, then you can send him to custody. If magistrate is the opinion that such person can be released without hazard to community or to any person, then you can release him also. After 6 months, after 6 months, 7 months, everybody, once all this judicial process is starts, everybody will mellow down. No? He will try to, improve himself. And if the magistrate is of the view that he has improved a lot, and if I release him back to the society, he will not be in hazard to the society or the community, then you can release him also. Now, this is another chapter, chapter 11. Chapter 10 is not important to discuss, because that chapter 10 deals with the power to grant maintenance to the women and children. Actually, if you see the CRPC, section 125 of CRPC, there are provisions which says that a magistrate can pass orders where he can grant certain maintenance allowance to women and children. But now, after the Family Courts Act, now all these powers relating to a dispute between husband and wife is now, it is with the court. It is the district judge who is the authority. So now even the judicial magistrate doesn't have these powers. Now this is chapter 11, section 148 to 167. These are the provisions which is important for the magistrate. There are a lot of power given under these provisions also. Now, section 148, magistrate may command any unlawful assembly or any assembly of 5 or more persons likely to cause disturbance of public peace to disperse. So this is what I was discussing. Actually, it starts from here only. If not dispersed, civil force can be used for dispersal. Now you must be wondering, what is civil force? This is the minimal force which you can order to apply. Minimal force without causing any injury. Although you have the power powers to, command the armed forces also to disperse the assembly. But this will be your first step. Try to use the minimal force to disperse. Now 149, if any assembly as aforesaid cannot be dispersed and dispersal is necessary for public security, DM or the magistrate authorized by him may cause it to be dispersed by using armed forces. Now, if that is a civil force, this can be now we can say that this is a criminal force, although we don't say that. So, now you can use the armed forces. This will be like lathi charge and all, even tear gas, lathi charge. Sometimes, you give orders to fire also. So, this is use of little bit more force. Arrest and detention of such person can be made to disperse such assembly. You can order to arrest also and detain them in custody just to disperse the assembly. I am talking about unlawful assembly. There is a difference between assembly and unlawful assembly. And this is for you to decide whether this is an unlawful assembly or this is just an assembly. Because assembly means even this is an assembly, gathering of the people. But this is not unlawful. So you have to take a call whether a particular assembly is an unlawful assembly or not. You can arrest. Little force and injury as may be required should be used for such dispersal. So that is, general thing. As little as possible, force should be used. Because, what the legal jurisprudence say, that state cannot use such kind of force which should not have been used to its own citizen under any circumstances. That's why a lot of cases have been filed before the High Courts and the Supreme Court challenging this kind of orders. This kind of force was not necessary, but police use this kind of force. How police use that force? Because it was given by the magistrate. It was because of your order they have used the force. 151. All persons are protected for any act done under 148, 149 BNSS. If you have ordered the use of force, you people are protected. I thought this is very important provision for you all, because this provision gives you the immunity not to be prosecuted before the court of law. But this immunity is not absolute. Except with the sanction from government. So, you are vulnerable to judicial scrutiny. This is what I say. So, if you have used the force, if you have ordered to use the force without any justification, and if the force which was used by the police was higher than what was required, then you can be booked and prosecuted. But government sanction has to be there. Using force under these sections shall not be considered as an offence if reasonable and justified. This is the crux, actually. If your order is justified, then you will not be answerable. But if your orders are not justified, then you have to face the prosecution before the court of law. 152. Now, these are the provisions with regard to public nuisance. Magistrate, on receipt of the police report or other information, it is commencement of period for which surety is required, contents of the bond, up to this 137 up to 139. I have not included in the PPs, but I suggest that you should read these provisions also. Content of the bond What will be the content of the bond? That is also given in that provision. Now 140. Magistrate has power to reject surety produced by such person or surety previously produced by such person. Now, in a case, all the formalities have been completed, you have conducted the inquiry, everything is done, and now you are passing the order that Mr. X should execute a bond with sureties. And if he brings a surety having a more criminal record than him, then what you will do? Will we accept that? No, you will not accept it, because you have the powers, you can reject. So you will ask him to produce someone with better character. Even the court will do the same. We don't accept the surety of such person who does not have proper documents. Because what is the duty of the surety? Duty of the surety is to take responsibility of this miscarriage. And if surety himself is a greater miscreant than him, then tomorrow both of them will, run away. They will vanish in thin air. So always ask some good person to be the surety. Ask him to bring someone having proper documents. You cannot say that you have to bring a person with good character to be the surety. Maybe that will be too much. But if you have a doubt, then you can reject that surety and ask him to bring another surety. Or you can ask him that bring one more surety. Surety के ऊपर एक और surety. Magistrate shall hold such inquiry before rejecting surety. Now this is the procedure. You just can't reject. You have to hold inquiry. Why you are rejecting? What are the reasons? You will have to find it out. Then only you have to reject it. Notice to be given to the surety and the person before holding inquiry. Now, notice to be given to the surety. Surety word has already come here. Why? Because this is the case where, in a case, a magistrate has already accepted surety. He has already bind him down and accept surety. But later on, if the magistrate comes with certain facts that the surety is not proper, then in those old cases also you can ask him to change the surety or bring a new surety. You will reject that surety also. That is why this third line, notice to be given surety. So, if you are rejecting that surety, then you have to give notice to that surety also. I am rejecting your surety. If you have anything to say, you appear before me on this date and put up your submission. And even you have to give notice to the miscreant also. Because I have mentioned such person, I don't want to mention that miscreant, word miscreant, because it may not be proper. But you have to issue notice to the miscreant also. Why? Your surety should not be rejected. So after inquiry, if surety is found unfit, may reject such surety with reasons. So reason is everywhere. And it is important that you have to give reasons before you pass any orders. Do not pass any orders without reasons, because that is what will be challenged later on. This is a blanket order without reasons, so this will not sustain. And the higher courts will, in most of the cases, they will set aside this kind of orders if the orders are without reasons. I know there are instances where it will be difficult to give reasons. I have also faced a lot of difficulties giving reasons, but always try to give reason. Maybe it's a flimsy one also, but give some reasons, so that later on the higher court might not say that this order is without reason. Now 142, magistrate can release any such person imprisoned who failed to give surety. If all the process is completed, you want to bind him down, but he is not bringing the surety, then you can send him to custody. If magistrate is the opinion that such person can be released without hazard to community or to any person, then you can release him also. After 6 months, after 6 months, 7 months, everybody, once all this judicial process is starts, everybody will mellow down. No? He will try to, improve himself. And if the magistrate is of the view that he has improved a lot, and if I release him back to the society, he will not be in hazard to the society or the community, then you can release him also. Now, this is another chapter, chapter 11. Chapter 10 is not important to discuss because that chapter 10 deals with the power to grant maintenance to the women and children. Actually, if you see the CRPC, section 125 of CRPC, there are provisions which says that a magistrate can pass orders where he can grant certain maintenance allowance to women and children. But now, after the Family Courts Act, now all these powers relating to a dispute between husband and wife is now, it is with the court. It is the district judge who is the authority. So now even the judicial magistrate doesn't have these powers. Now this is chapter 11, section 148 to 167. These are the provisions which is important for the magistrate. There are a lot of power given under these provisions also. Now, section 148, magistrate may command any unlawful assembly or any assembly of 5 or more persons likely to cause disturbance of public peace to disperse. So this is what I was discussing. 144 para. Actually, it starts from here only. If not dispersed, civil force can be used for dispersing. Now you must be wondering what is civil force. This is the minimal force which you can order to apply. Minimal force without causing any injury. Although you have the powers to command the armed forces also to disperse the assembly, but this will be your first step. Try to use the minimal force to disperse. Now 149, if any assembly as aforesaid cannot be dispersed and dispersal is necessary for public security, DM or the magistrate authorized by him may cause it to be dispersed by using armed forces. Now, if that is a civil force, this can be now we can say that this is a criminal force, although we don't say that. So, now you can use the armed forces. This will be like lathi charge and all, even tear gas, lathi charge. Sometimes, you give orders to fire also. So, this is use of little bit more force. Arrest and detention of such person can be made to disperse such assembly. You can order to arrest also and detain them in custody just to disperse the assembly. I am talking about unlawful assembly. There is a difference between assembly and unlawful assembly. And this is for you to decide whether this is an unlawful assembly or this is just an assembly. Because assembly means even this is an assembly, gathering of the people. But this is not unlawful. So you have to take a call whether a particular assembly is an unlawful assembly or not. You can arrest. Little force and injury as may be required should be used for such dispersal. So that is general thing. As little as possible, force should be used. Because what the legal jurisprudence say, that state cannot use such kind of force which should not have been used to its own citizen. under any circumstances. That's why a lot of cases have been filed before the High Courts and the Supreme Court challenging this kind of orders. This kind of force was not necessary, but police used this kind of force. How police used that force? Because it was given by the magistrate. It was because of your order they have used the force. 151. All persons are protected for any act done under 148, 149 BNSS. If you have ordered the use of force, you people are protected. I thought this is very important provision for you all, because this provision gives you the immunity not to be prosecuted before the court of law. But this immunity is not absolute. Except with the sanction from government. So, you are vulnerable to judicial scrutiny. This is what I say. So if you have used the force, if you have ordered to use the force without any justification, and if the force which was used by the police was higher than what was required, then you can be booked and prosecuted. But government sanction has to be there. Using force under these sections shall not be considered as an offence if reasonable and justified. This is the crux, actually. If your order is justified, then you will not be answerable. But if your orders are not justified, then you have to face the prosecution before the court of law. 152. Now, these are the provisions with regard to public nuisance. Magistrate, on receipt of the police report or other information and on taking evidence as it think fit, that unlawful obstruction and nuisance be removed from public place, way, river or canal. So I think you people must have done this many times. Even I still remember there was one drive in MG Map where all those, materials which were displayed outside on the footpath and all, that were removed by this is a long time back. So that is under this provision actually. If it is obstructing the way, if somebody has parked a vehicle on the footpath, then you can order, remove this, otherwise a kind of easement, but public way. Obstruction. Even in easement also, you can do that. Then, conduct of trade or occupation is injurious to health or physical comfort of the community. If somebody is selling something which is not actually good for the health of the community, then you can order to stop this nuisance. Construction or disposal of any substance is likely to cause explosion. In these also you can act. Building, tent or structure or tree which is likely to fall and cause injury. I think recently I saw it in the paper, I think that Sisagolai, one of the building has been sealed. So this is under this provision actually. That is, it might collapse and cause injury to the public. So this is under this provision. Any tank, well or excavation at any place should be fenced. Here in Sikkim we don't have wells. But you must have seen in TV and all, no? In other places that some, a child fell in borewell and all DCs, DMs and all are there, all police commissioners are there and they are excavating just to rescue that child. Why they are doing so much of exercise there? Because it is the responsibility of the DM to see if an unfenced well or unfenced, things are there which is hazardous to the public, then it should have been fenced. So So any dangerous animal should be destroyed or be confined. I don't know whether now we can do this or not, because dogs are, they are now more powerful than us. But this provision is there in BNSS. Maybe you can confine. If it is endangered, then obviously you have to do it. Yes, you can tranquilize the animal and you can keep it in some safe place. To me also, if there is a specific law passed by the Parliament or there is a specific law laid down by the Supreme Court, then it is not proper to go beyond the orders of the Supreme Court or the law. General laws, because this is a procedural law actually. CRPC has a procedural law actually. So those law will supersede, like you said, those law will supersede. Now I think this destroy should have been removed from the book only, but it's still there. That's why I'm saying nowadays dogs are powerful than us. They can move up to Supreme Court and get a favorable order, and still we are grappling. We have not been able to move up to Supreme Court. Magistrate may make conditional order to remove such obstruction or nuisance, desist from carrying on such trade occupation, stop construction or disposal of such material, remove, repair or support such tent, building, tent or structure, fence the tank while excavation, destroy, confirm or dispose. And these are the remedies. You can pass this kind of orders. Remove it. Except destroy the animal. Don't destroy it. For that, I think there is no such specific provision given in the book also, whom you should write. If it is a private property, then you can direct the owner of the property to do it. If he is not doing it, and coming to that also, you can do it yourself and recover the amount from him. That provision is there. If any contractors are there, if a building is being constructed by a contractor, you can direct him. You do this, otherwise you will have to face the consequences. That provision is there. We will deal with it also. If such person objects to do so, he has to appear before the magistrate and show cause as to why the order should not be made absolute. If you have directed some contractor, you stop the construction because this is hazardous. Then if he is not, obeying your orders, then you have to make sure that he will present himself before you, and you can issue the notice or show cause kind of thing, saying that why this order should not be made absolute. If there are no reasons to support his contention, then you can always stop, like you did in this Sissagola case, a lot of orders. These orders the magistrate cannot be questioned in a court of law. This is a good provision of law. So if you have passed this kind of order, then it will not be questioned before the court. Nobody can challenge this. Now this is 153, 154, 155 BNSS. Such order needs to be served upon the person. This is actually the procedure. When you are trying to stop some kind of nuisance, that this is the procedure to be followed. You just cannot pass order directly. First you have to conform, you have to follow this procedure. And once you pass the order, you have to serve this order. I believe everybody is doing this. You have to serve these orders to the concerned person against whom you have made the order. Such person has to obey the order or appear and show cause. And such appearance may be permitted through VC. This is a new provision which is now added in the BNSS. Earlier this provision was not there. So now I think you have to be little bit technical in this. IT, professionals are required. Now you have to set up a BC facility in your offices also. Because this provision, if you have issued a notice to some contractor that your construction is hazardous, then if he asks you that I'll appear, but I'll appear through BC, because law says so. You can always, you have ways and means to pull the air. You can do like this also, you can do like this also, ways and means. But if somebody insists that because of this is reason I am unable to come, please connect me through BC, then maybe you have to have this facility. Because somebody might challenge it, saying that law says that I can appear through BC, why he is calling me? That is what. You can say discretion of magistrate, but with this kind of cases, what discretion you will. If I am in Siliguri and if a notice is issued against me and I say that I am in Siliguri, I want to appear, give me the BC, then what discretion you will execute in that, apply in that. Magistrate has powers for local investigation and examination of any expert. This power is also given to you. Local examination, local investigation. You can do it yourself also. You can depute someone also. A responsible officer, you can depute also. Magistrate can direct investigation by some person and may summon an expert and can give written instruction as will be necessary for guidance. If you are deputing someone, then you can give the certain instruction in writing also, like terms of reference. Because he may not be knowing what he is supposed to do at this spot. So, since you are seizing of the matter, you are conversant with the facts of the case. So you can say that this is the facts. So you have to go and see this at this spot and give me the report. That you can do. Such report of such person can be read as evidence in the matter. So if you have deputed your deputy or your subordinate officer, and if he files a report, then you can take that report as evidence when you are deciding the case. Although it's not an absolute evidence, but for you it is sufficient. Once the order becomes absolute, magistrate shall give notice of the same like the other provision to such person. If not obeyed, such person shall be punished under 2 to 3. I think your answer is here. This 2 to 3 is applicable in this kind of cases because that is an order passed by a public servant. So magistrate may cause to perform such act and recover cost from such person by attachment and sale of his properties. It's not in cognitive law. So you have to forward it to the court of the judicial magistrate, then court will deal with it. Now this is your answer. Attach and sale of the properties. Even in case of disobedience also. If somebody is not obeying your order, like I said, you fence it yourself and recover the cost from the owner of the property. It was your duty to do it. Since you have not done it, I have done it, and now give me my money back, what I will spend. 161. If magistrate considers that there is imminent danger, injury of any kind to public, he may also issue order of injunction. This is one good provision. You have been given the powers of the civil court here. You can pass injunction also. Now what is injunction? Injunction is an interim order. An order passed in between the proceeding. You have not completed the proceeding. Maybe the inquiry is pending. You have not passed your final order, but you are of the view that I have to pass certain orders just to protect the property or to do justice to the parties. So in those situations, if there is an emergency situation which needs urgent intervention from your side. Then in those cases, you can justify your action and pass an order of injunction. Like, you should not be doing anything in this property until I said so. So after you dispose of the case, then this injunction will automatically be vacated. Because after the final order, there will be no need for this injunction order, because you will be deciding the case finally. So until then, you can pass injunction orders also, just to injunct someone, just to refrain someone from doing certain acts. If injunction order not obeyed, magistrate can use such means which it thinks fit to prevent such danger. Like we have already decided, if there is an imminent danger and he is not obeying, then you can do it, or you can employ someone, you can direct someone to do it and recover the money. Now 162, magistrate may pass order not to repeat or commit a nuisance. This kind of orders also you can pass. If magistrate has 163, if magistrate has sufficient ground and to prevent immediate danger, may direct any person to abstain from doing certain act or to take certain order in respect of certain property if he consider that this will prevent obstruction, annoyance or danger to human life, health and safety, or disturbance of the public tranquility or right. This order can be passed ex parte. So this is akin to 144. Earlier in the CRPC it was section 144, now it has become 163. So in these circumstances you can pass this 144 orders. That is curfew. Actually in the simple words we can say that is curfew. Curfew lage. So you will pass curfew order under this. Curfew lage, it will be imposed in certain locality or certain area. So your order under section 163 can be against an individual also or against a community also. Order shall remain in force for 2 months. If you pass an order today, it will remain in force for 2 months from today, not beyond that. You have the powers to impose 144 or curfew for 2 months, maximum period of 2 months. Although त्यत्रो लामो हुँदैन, प्राय केसहरुमा ज्यादा से ज्यादा हप्ता दिनको हुन्छ, 1 week, but 2 months सम्म दिनु सकिन्छ. Now government has the power to extend it. Government can extend it for 6 months. Magistrate either on his own motion or application rescind or modify such order. Curfew order can be modified. News ma sunnu huncha ni आज बिहान सौदा गर्नुको लागि छुट दियो अरे. This is what is there in the provision. So फेरि सौदा गरिसकेपछि फेरि पहिलाकै जस्तो भयो. Early hearing of the application to be given, if rejected, reasons to be recorded. Now if somebody has filed an application before you saying that you have imposed the curfew, now because of your curfew we are facing certain difficulties. Definitely when you are not allowed to move freely outside, then we will have difficulties. No? So somebody can come before you with an application that you need to modify this curfew order because of this reasons. So you can inquire, you can verify if there are genuine problems, then you can modify the order, and if such application comes before you, then as far as practicable, you need to give an early hearing to it. You just cannot keep this application, pending for 3 months, 4 months, and you are not taking the hearing of that party. You have to give the early hearing so that you can, if need is there, then you can relax the order. And if you are rejecting that application, like I said, reasons to be recorded why you are rejecting it. As a mood chaina bhannu chahi mileन. reasons of the inquiry. Now 164, dispute as to immovable property. There are certain powers given with regard to this also. When magistrate is satisfied from the police report or the information received that a dispute concerning land or water is likely to cause breach of peace, he shall order requiring the parties to appear and put up written statement of their respective claims. This is quite a lengthy process actually. Here the parties collect evidence and may decide who is in the possession of that property. Like I said, you can only decide possession on the property. Aile meroma थियो भने you can decide that उहाँकोमा रहेछ. तर को यसको actual owner हो त्यो चाहिँ decide गर्न सकिँदैन executive magistrate को बाट. यो सबै गरेर you can confirm who is in the possession. If any of the party dies, legal hires to be substituted. If in between the proceeding somebody dies, then these are her legal heirs to be made as party to this proceeding. Somebody has to be there from their side. And if dispossessed within 2 months before the police report, he may be considered as the one in possession and sustained. You know, in sometimes what happens, case file गर्नु भन्दाखेरि अलिक अगाडि मात्रै मान्छे लगाएर बाङबुङ भत्काएर निकालिदिन्छ. Then the same fellow will go to the executive magistrate court and file an application. In these kind of cases, if that person was in possession of that property 2 months prior to the report of the police, then you can say that since he was in possession of that property, let possession remains with him only until decided by the court. So I think this, you keep on doing this. Only thing is that you have not, gone through the entire provisions of the law. You are doing this, especially the magistrate in Gangtok and Namchi. Lot of cases comes. If a cross order produces their magistrate may order for proper custody or sale of such property, order for disposal of such property. If in a disputed property there is a standing crop, then you can pass certain appropriate orders. So, on application by the party, magistrate can issue summons for attendance of a witness or to produce documents. Now, in the book only this expression is there. Land and water includes building, market, fisheries, crops and other produce and rent and profit of such property. This is also included as land and water. If there is a certain income from the water, that is also included. If there is a standing property or certain income from the property, that is also considered as land. So when magistrate considers as there is an emergency or is satisfied that none of the parties were in possession of the property in dispute, he may attach such property until a competent court determines the right of the property and appoint receiver to look after the property. I think you must have been doing this. Receiver can be appointed. Receiver means a receiver is a person, an independent person who will look after the property. If no likelihood of breach of peace with regard to the matter in dispute, magistrate may vacate the attachment. So if a particular property is there where there is a dispute and there is a likelihood of breach of peace, then you can attach the property for the time being, just to avoid all those situations. And when everything normalizes, you can again vacate it. If a magistrate satisfied with the report of the police or upon information received that a dispute regarding the use of land or water is likely to cause breach of peace, he may order parties to attend his court and file written statement. After hearing parties and receiving all evidence, decide whether such right exists or not. if it is satisfied that such right existed, make an order prohibiting any interference with the exercise of such right and may order for removal of obstruction. Like तपाईले सोध्नुहुँदै थियो कि first you have to decide right थियो कि थिएन. If there was an existing right, then you have the powers to pass certain orders, like the one mentioned here at the bottom of the slide. But तपाईले पहिला चाहिँ इन्क्वायरी गरेर चाहिँ राइट एक्जिस्ट गर्छ कि गर्दैन त्यो चाहिँ डिटरमाइन गर्नु पर्यो. ब्ल्याङ्केटली केही पनि कुरा पास गर्न चाहिँ मिल्दैन. तपाईले you can call the parties, ask them to file documents. You can even call the witnesses, locality people, panchayat, responsible persons from the locality. So from that you can determine. Like for doing all this you have the right powers of the civil court. You can summon the witnesses. If somebody is reluctant to come, you can ask them to be produced through the police. In court though we issues, warrant also against the witnesses if they don't appear. Police will arrest them and bring them before the magistrate. Once the examination is done, you will release them. Now, whenever local inquiry is necessary for the purpose of section 164, 165, 166, for determining all these things, if you need a local inquiry, magistrate may depute any magistrate subordinate to him to make inquiries. Like this was there in the last slide also, regarding that nuisance and all, in that chapter also. So report of such person can be read in evidence. Like I said, if your subordinate officer has filed a report, then you can consider that as evidence and act upon it accordingly. Magistrate can make an order for cost and expenses. If there is a cost and expenses involved, like some of the applicants might say that I have engaged the lawyer. I am paying 5,000 per day to my lawyer. So because of this fellow, I have to engage this lawyer and I am paying. If you consider necessary, then you can award some cost also. Like if you have seen the orders of the courts, High Court and Supreme Court, even lower courts also, at the last page, at the last line, there is one paragraph. In some of the case, the court might say there is no order as to cost. That means parties has to bear their own cost. But in some of the cases, court will say that this much amount has to be paid by the defendant to the 20 less cost. That means court is reimbursing the expenses incurred by one of the parties. So likewise, you can also pass an order for cost. Now, this is one of the most important power and one of the most, delicate powers given to the magistrate. Although earlier there used to have a lot of remands by the executive magistrate in Sikkim, nowadays we have judicial magistrate in all the subdivisions. That's why I think you all are not receiving this kind of cases. Like what happens, earlier IPC provision is 167. What section 167 says, or 187 BNSS says, when a person is arrested and detained in custody for committing offence and the investigation cannot be completed within 24 hours, accused can be produced before a magistrate for remand. There are two kinds of remand. One is police remand, one is judicial remand. In police remand, accused will be sent back to the police for further inquiry and investigation. In judicial remand, you will be sent to the prison. Now this power is given to the judicial magistrate also. Judicial magistrate already has this power. But what is there for the executive magistrates? If you see 187(6), you will find that Where judicial magistrate is not available, executive magistrate can grant remand. You have the power to grant remand. You can remand if a person, a thief, a rapist or a murderer is produced before you with an allegation that he has committed certain offences, then police will file the requisition before you saying that we need his presence in the police station to further investigate the matter. And you have to go through the entire thing. It's not that you can just in a routine way remand the accused back, because there are repercussions and consequences of remand even to the magistrates. I'll come to it. Now you can remand for 7 days. Maximum period you can give is 7 days, not more than that. But as for the CRPC, a judicial magistrate can grant remand for 15 days. Not more than 15 days, but you can give only for 7 days. After 7 days, accused along with the entire case papers need to be forwarded to the nearest judicial magistrate. So if police is again coming to you after 7 days for further remand of the accused, you don't have powers. You have to forward the accused along with the case paper to the nearest magistrates. And from 7 days onwards, magistrate will pass the appropriate order in this. Whether he has to be sent back to the police custody or he has to be sent to judicial custody. Now, while granting remand, this is important. Please listen to it carefully, because if something goes wrong, then you will be held responsible. While granting remand, prima facie material needs to be verified. If somebody is arrested and produced before you, and if police does not have any papers, neither the FIR nor the inquiry, nothing, yes, then you should not remand this kind of cases. Because there has to be some material to justify his arrest. So until that material is there, don't remand. Because there are strict provisions of law and there are judgments of Honorable Supreme Court which says that if someone remands an accused without looking to all these things, then there shall be a departmental inquiry against him, and if the police has not followed the proper procedure, then they should be charged for contempt of court. Arnesh Kumar versus State of Bihar. Check any sign of assault or injury in custody. This is also important. Because if you have remanded an accused and tomorrow that accused dies, then you will be held responsible in custody. Another, check medical report and verify if medical assistance is required or not. This is also important. Because some of the arrested person might be suffering from some kind of illness. Maybe he's a diabetic, maybe he's an asthmatic. So if those conditions exist, then you have to verify and direct the police that you provide him the proper medical support as and when required. See if section 35, 1 and 2 of BNSS are complied. So what is this one, 35, 1 and 2? This is section 41 of CRPC. Section 41 of the CRPC or this 35 of BNSS says that if a person is arrested for the offence which is punishable less than 7 years, then normally police should not arrest this kind of accused persons. They should issue the notice first, ask him to appear before the police, and if somebody is arrested, then police has to justify why they have arrested this accused. So there are a lot of things in 135 you can read, because of the time constraint I am not replicated the entire provisions. Because earlier there was 41, 41A in CRPC, now it is 35 only, and they have divided the provision into 1 and 2 subsections. Now, if an offence is punishable less than 7 years or up to 7 years, police cannot arrest on his satisfaction only that an offence has been committed as aforesaid. This is the provision 35. पुलिसलाई लाग्यो कि यसले अफेन्स गर्यो भनेर मात्र चाहिँ हुँदैन. There has to be something more. And when such person, arrested person is produced before you, you have to verify this. के चाहिँ थियो कारण एरेस्ट गर्नु? अब कारणहरु के हुन सक्छ? यो मान्छेलाई एरेस्ट गरेन भने he is from some other place, he might have scored. यति साह्रो notorious हो, if he is not arrested, tomorrow he will commit again another offense. These are some of the grounds, some of the reasons. So use justify गर्नु पर्छ. Has to satisfy that the arrest is necessary and reason for arrest must be given, like I said. Instead of arrest, notice has to be issued, like I have already mentioned this also. Reason for not arresting must also be given when not arrested. This is quite a difficult provision, but this is not applicable to you. This is for the police to see. If police is not arresting an accused who is charged with an offence which is punishable below 7 years, then police has to justify before the court, before the magistrate, why he did not arrest the accused. It's not only arresting, but if you are not arresting also, you have to justify both your actions. Automatic arrest must be discouraged and checklist is forwarded to the magistrate furnishing materials and reasons why which necessitated arrest. So you have to check this checklist. Nowadays the police have started preparing this checklist after the judgment of the Supreme Court. You have to verify this. If some of the accused persons are produced before you by the police, then you have to verify all these things, then only remand the accused. Now why this is a tricky provision? Because Article 22(2) of the Constitution gives certain powers to the arrested person also. He has to be produced within 24 hours. A person arrested cannot be detained more than 24 hours by the police without the authority of the magistrate. That's why need is there to produce the accused before you, if a judicial magistrate is not available. Detention affects liberty and freedom. Needs to be exercised with greater care and caution. This is my words, my line. It's not in the book. Why you have to be careful? Because these are constitutional provisions. Detention means you are infringing someone's freedom, someone's liberty. So if you are curtailing someone's liberty, then you have to be very, very careful. Magistrate to peruse such report of the police and authorized detention only after satisfaction. No compliance would lead to departmental inquiry and liable for non-compliance would lead to departmental inquiry and liable for contempt against police. So this is the case. Arnesh Kumar versus State of Bihar, AIR 2014 SC 2756. I'll just read the directions of the Supreme Court only. I have not replicated there. What are the directions? Let me read the operative portion of the judgment. Our endeavor in this judgment is to ensure that the police officers do not arrest accused unnecessarily and magistrate do not authorize unnecessarily detention. And mechanically, in order to ensure what we have observed above, we have given the following directions. All the state government to instruct its police officers not to automatically arrest when a case under section 498A of the IPC is registered. Actually, this case was with regard to section 498 of IPC. 498 is this: cruelty by the husband against the wife. So this case was regarding that. It traveled up to Supreme Court, but what the Supreme Court is saying that These directions are not limited to 498A cases, but these directions are applicable to all the cases. That's why this is applicable in other cases also. All police officers be provided with a checklist containing specified sub-clauses under section 41(1)(b). This 41 means, now this is 35, section 35 of BNSS. So all those, do's and don'ts which are there in 35, police has to prepare the checklist. And while remanding, you have to check all those details. Now, police officers shall forward the checklist duly filed and furnish the reasons and materials which necessitated the arrest while producing the accused before the magistrate. Now, detention and the decision not to arrest, like I said, the accused be forwarded to the magistrate. Now, the most important part is failure to comply with the direction above shall, apart from rendering the police officer concerned liable for departmental action, they shall also be liable to be punished by contempt of the court. And there is for magistrates also. I think that photo is not there. For magistrate, if Supreme Court says that if you remand some accused person without complying with all these provisions, then there will be a departmental inquiry and disciplinary proceeding against you also. This is for the magistrates, judicial magistrates. So the Supreme Court has said that High Court will take a departmental inquiry against you. But if it is against you, then government will have to take it. So that's why, although this provision is there, you have the power to remand an accused at least for 7 days. But if you are exercising this power, be careful and follow the entire procedure. And if you take my advice, if you ask me what to do in these kind of cases, I will tell you that as far as practical, avoid. That is the best option. If you can avoid, please avoid. I should not be saying this, but that is the best option. Because, police might manipulate you. No, most of the senior officers are now aware of this. Because last time, there was one matter which traveled off to Supreme Court where 3 of our police officers were nearly, issued a contempt notice by the Supreme Court. I was the one, along with the Chief Secretary sir and DGP sir, we sat together, we prepared the report, and somehow we could justify their action and file an affidavit before the Supreme Court. I don't want to name the officers, there were 3. Now they are in the rank of DSP. So this is this. This is also another provision which needs your attention. Inquest. You all are doing the inquest. 194 of BNSS. So inquest, what is inquest? This is a judicial inquiry into the matter. Cause of death actually. When report regarding unnatural death is received by the police, they shall give information to executive magistrate empowered to hold inquest. Information also inquest going. Once inquest requisition comes, then you have to go to the PO where the dead body is lying, and you have to record the entire thing. Now, such report shall be signed by the police. Once you complete the inquest, then it has to be signed, and there has to be witnesses also. Now, these are some of the tips which in my view are important for you all. I have just jotted it down. Inquest is one of the most important functions for a magistrate has to perform. Physical inspection of the PO and the dead body is important. Why this is important? Because you are one of the witness before the court after you become signs the inquest report. You will be called as a witness before the court. And what happens before the court, you all know. There is examination, cross-examination. And if you have not done it properly, then in cross-examination, you will face the music. Rock, heavy metal music. You know how the defense lawyer put questions on you. That's why it is very important. Involve yourself totally so that you can remember all those things. Timing, these, that, witness. Now, recording of the PS case number, distance from the PO, this identification mark on the dead body, position of the dead body, these, that, you all know. You record all these things. Even police will help you to record all these things. Actually, this has to be there in the report, inquest report. Name of the witness. A witness pani locality badai hunu parcha bhancha actually. You cannot put some pocket witness. You just cannot carry some witness along with you to stand as a witness in this inquest. And it is very hard to find witnesses. Nobody is willing to be a witness in this kind of cases. Involve all the witness in the process of inquest. Normally what happens, witness will be sitting outside. They did not have any chance to come inside the room where the dead body was lying. And at the end, when everything is done, they will sign the inquest paper as a witness. And what happens when the case goes to the court? Defense counsel will start grilling you. What you saw, what was the position of the dead body, whether it was in supine position, whether blood was there, what kind of wearing appearance the dead body was having. So, if he has not seen anything, then he will not be able to answer it. That means, ultimately what happens, court will come to the conclusion that this witness was not present at the PO. When he is not present at the PO means his entire evidence is won. That's how you get an acquittal in the court. So try to involve. This is for the police also, not only for the magistrates, because your duty is to prepare the inquest report only, not to prove the case. But since we all live in same society and it is always better for everyone if we can punish the perpetrators. So read over the contents of the inquest. Involve witnesses from the locality. Stay calm and composed during cross-examination in the court. I don't know how many of you have faced the cross-examination before the court. It's really a difficult thing. Really difficult. If, good lawyers are there in defense, then you will have it. First and foremost, what a good lawyer will do? He will try to provoke you. Once you are provoked, then it's easy for him to demolish you. Risu udeपछि त्यहाँदेखि मुखबाट जेसुकै निस्किन्छ, you are gone then. That is what they do. That is what they do. So if you stay calm and composed, they cannot demolish you. Yes, they will play with your mind. No? That is their duty, that is their job. They are paid for that only. And they take it in lakhs. Yes. They will put some unnecessary questions just to provoke you. जब रिस उठ्छ त्यहाँदेखि they will come to the main questions. Then तपाईहरुले जेसुकै भनिदिन्छ गयो त्यहाँबाट सबै. That is called the court craft actually. Because I was a lawyer for 12 years. So I have also done that in many of the cases. रिसाको मान्छेलाई लथालिङ्गे पार्नु एकदम सजिलो हुन्छ. एकपल्ट कन्सिले तताइदिएपछि त्यहाँबाट त्यो मान्छेले जेसुकै भन्न थाल्छ हो. त्यहाँदेखि थिएकोले बिगार्छ. एउटा अफिसर, पुलिस अफिसरको जू भन्ने थिएको थियो. जू मैले त्यो ज्यूमै केस जितेँ. He has retired. He is also Chettri and retired. Long time back. He was in Ranipur PS. I think he retired as SI. ज्यू भनेर बिग्रियो उसको. ज्यू भनेको त हो भनेको बुझिन्छ नि. खासमा उसले त्यो हो भनेको होइन. म्याजिस्ट्रेट्स अल्सो बिजी. दुनियाँभरिको केस हुन्छ, जाङ हल्ला हुन्छ हो. पुरा सुन्छ. I took the advantage of that. In case of unnatural death, as mentioned in section 194 BNSS, more particularly in case of death of the woman within 7 years of marriage or there is a doubt regarding cause of death or any person dies or disappears or rape is committed upon a woman while in custody, the magistrate requires to hold inquest or hold an inquiry in the case of death. यो चाहिँ magistrate inquiry भन्छौँ नि त्यही हो. Custodial death भयो भने र कतिवटा custodial death होइन भने अरू केसेसमा पनि you need a magistrate inquiry. त्यसमा चाहिँ यो सेक्सनमा हुन्छ magistrate inquiry. यो चाहिँ inquest होइन. This is a full-fledged inquiry actually upon the incident. Inquest is different. Inquest is limited up to the dead body only, the death of the person. But this inquiry is an overall inquiry into the cause of death and the related incidents. Evidence record गर्नुपर्छ तपाईहरुले यसमा. Dead body examined, informing the witness within 24 hours, forward the dead body for medical examination if you are an inquiry officer in this judicial magistrate inquiry. यो सबै प्रोसिजर तपाईहरुले फलो गर्नुपर्छ. Now we are coming to the good slide, I must say. Now we have come to the marriages. Apart from all this, you have this duty also. There are various personal laws under which one can solemnize marriage, like Hindu Marriage Act, Anand Marriage Act. Anand Marriage Act is Sikh Marriage Act. It is not extended in Sikkim, but this is Sikh Marriage Act. Muslim Marriage Act, Christian Marriage Act. This Muslim Marriage Act, Christian Marriage Act, these are not extended in Sikkim. Special Marriage Act is here in Sikkim. That too was extended in I think 2018 or 17. And in Sikkim we have these rules. Rules to provide for registration of a form of marriage in Sikkim, 1963. Notification number 1520/H. This is the pre-merger rule, which is still existing in the state of Sikkim, under which you can solemnize your marriage. मैले मेरो आफ्नै चाहिँ गरेको छैन रेजिस्ट्रेसन अहिलेसम्म. यसमा सबै प्रोभिजन छ. यसमा तपाईको बिहे गर्ने प्रोभिजन पनि छ, डिभोर्स गर्ने प्रोभिजन पनि छ, सबै प्रोभिजन छ. स्पेशल म्यारेज एक्ट र यो एउटै हो, तर यो चाहिँ सिक्किमले बनाएको हो. स्पेशल म्यारेज एक्ट चाहिँ सरकार भारत सरकारले बनाएको, त्यति मात्र फरक छ. मोस्ट अफ द प्रोभिजन्स आर सिमिलर टु स्पेशल म्यारेज एक्ट. नाउ Hindu Marriage Act 1955 is extended in force in the state of Sikkim. Now, यसमा तपाईहरुलाई powers दिएको छ registered marriage register गर्ने. So, under section 8 of the Hindu Marriage Act, rules 1991. I have the copy of the rules in physical form. Even I have the copy of the rules in digital format also. I can share it with you. Have been framed which provides procedure for registration of the marriage. DM, ADM and SDMs are the marriage registered under these rules. Not the ADC development. याद गर्नुहोस्. ADC development is not DM. It is not DM. DM means district magistrate, additional district magistrate and subdivisional magistrate. They are the marriage officers. Now, सिक्किममा एउटा पहिल्यैदेखि गल्ती हुँदै आएको कुरा चाहिँ के छ भने हामीले ट्राइबल्सलाई पनि म्यारेज रेजिस्टर गरिदिएको छौँ हिन्दू म्यारेज एक्टमा. यसमा कन्फ्युजन चाहिँ कहाँ छ भन्नुहुन्छ भने बुद्धिस्ट आर गभर्न्ड बाइ हिन्दू ल, बट ट्राइबल्स आर नट गभर्न्ड बाइ हिन्दू ल. He is not governed. He is not governed. Tribal Buddhists are not governed. Only the Buddhists are governed. If I am a Buddhist, but I am not a tribal, I can register marriage under Hindu Marriage Act. But Bhutia, Lepcha, they cannot. Even Limbu, Tamil, they cannot. Because they are tribals. Why? Because of this provision. Nothing contained in Hindu Marriage Act applies to tribal. Section 2, subsection 2 of the Hindu Marriage Act. You can register your marriage under the Special Marriage Act or under the Sikkim rules, but not under the Hindu Marriage Act. हाम्रो एकजना जुडिशियल अफिसर्स को भुटिया हो हिन्दू म्यारेज एक्टमा सर्टिफिकेट इस्यु गरिदिएको छ उसको सर्टिफिकेट हुन्छ
अहिलेसम्म जति इस्यु गरेको चाहिँ 100% तपाईँको हिन्दू म्यारेज एक्टको उसले गरिरहेको छ अब यो के हुन्छ
त्यो चाहिँ एउटा ठुलो क्वेशन छ मैले एकपल्ट ल्यान्ड रेभेन्यू सेक्रेटरी साहबसँग डिस्कस पनि गरेँ
यो त अरूले गरेको हैन सर सिस्टमले गरेको
couple whose families are not happy with their marriage. So like say one Chettri guy, he wants to
intercaste marriage.
Basically intercaste marriage. So for those
But there is no such restrictions to it. The Special Marriage Act provision says that any person intending to marry. Special Marriage Act. Because this is a neutral act. Special marriage. Yes. But it is not specifically for this kind of cases. It's not like that. It's not especially for those kind of cases which you are referring. Others also, when everybody is willing and if you are getting married, then also you can register your marriage under a Special Marriage Act. There is no bar to it.
Particularly religious marriage act, when that is applied. So, after marriage act, after divorce process, the succession process, you apply. But if a Hindu, suppose a Hindu can be married under Hindu Marriage Act, but they have applied under a Special Marriage Act, very Hindu Marriage Act को divorce succession laws भी apply होते हैं.
So far as Buddhists are concerned, or so far as tribals are concerned, तपाईहरुको codified law नै छैन अहिलेसम्म सिक्किममा. You don't have a codified law. Neither you have a codified law of succession, neither you have a codified law of marriage. Nothing is there. Although law department ma I have the books, but it is an uncodified law. There are local tribal laws of Lepchas also, tribal local laws of laws and customs of Buddhist Bhutias also, Sherpas also,
customary laws.
Customary laws, but none of these are codified. And what I have noticed is, in most of these laws, these customary laws, there is a contradiction. Like a Bhutia family residing in Viring has a different custom of getting married, and a Bhutia family residing in Mangan has a different forms and customs of getting married. So there are contradictions. So last time I was suggesting that why don't you all sit together and codify it? Because what happens is, since you don't have codified law, you will have problem in divorce. Where you will find it? Under what law?
So this is a agreement that must go. Is this achievable to Super and Tamil also?
No. Since they are tribals, yes. Once they are declared as tribals, it cannot be. You cannot apply to them also.
Super and Tamil also, sir?
Yes. They are notified tribals. No? Government of India has notified them as tribals. Even though they profess the Hindu law, you cannot apply this Hindu law. लिम्बूहरूको पनि सायद
You know, customary laws, according to the customary laws, lecture and if they can afford, they can have a polygamy relationship. Now, it is mentioned there in the case of Subba and Tanam.
सुब्बा तामाङको आफ्नो कस्टमरी लको अहिलेसम्म केही मैले पनि देखेको छुइनँ तर since they are declared tribals I don't think you can apply Hindu law to them also because specific provisions are act मा नै हो यसले भुटिया लेप्चा ट्राइबल केही भनेको छैन so far as tribals are concerned Hindu law is not applicable भन्छ भोलिको दिनमा मलाई ट्राइबल डिक्लेयर गर्यो भने म पनि हिन्दू लको अन्डरमा that act rules there are provision for divorce also हाम्रो rules मा पनि छ divorce को provision but divorce can be granted by competent court only don't try to pass an order of divorce at your level it is only and only the family court judge who can pass the order for divorce र कुनै पनि marriage divorce को decree बिना complete हुँदैन means divorce भएको मानिँदैन decree हुनै पर्छ court को decree
Sir, can we consider the paper which says that husband and wife they are mutually divorced and there is a witnesses also they have put their signature proper stamp of the lawyer can we accept those kind of papers as a
you cannot it is only the court who has the power to divorce tribals ko mata you can accept anything
so even I said to them this is not a family court order please you bring the family court but they said this is as good as the
so far as I think tribals are concerned since you cannot go to the court maybe you can consider their case because court ma गयो भने courtले petition accept गर्नु मान्दैन किन भन्दाखेरि you don't have law कुन चाहिँ law को under मा दिनु त्यसले गर्दाखेरि maybe for tribals you can accept it but not in other cases then you can divorce under that act only no that rules only there is a provision for divorce also under that rules even under special marriage act also there are provisions for divorce so if your marriage is registered under certain act then you can divorce under that act only na there is no issue at all but जो हामी जस्तो उहिले बिहा गर्यो अहिलेसम्म सर्टिफिकेट निकालेको छैन आजको दिनमा हामीले सर्टिफिकेट निकाल्नु पर्यो सपोज र पछाडी डिभोर्स हुनुको लागि जानु पर्यो भने चाहिँ देन कानुन छैन भने चाहिँ प्रब्लम हुन्छ कुन कानुनमा सर्टिफिकेट निकाल्ने र कुन कानुनमा डिभोर्स गर्ने So this is the competent court is the judge family court and in Sikkim judge family court is the district judge of the concerned district. Maybe for tribals special marriage act ma you have to I think register your marriage first under the act na to get your divorce under the act. Without registering your marriage you cannot apply. Even Christians also for Christians also we don't have a divorce law for Christians in Sikkim. Christian marriage act is not applicable in Sikkim. It's not extended. You can under the special marriage act you can. China Christian marriage act is not extended. Now another is you execute this also. Say give, exchange, deed, trust. And for this registration of documents rules 1930 is applicable. We don't follow the Indian Registration Act 1908. That is not applicable. That is not extended and enforced in the state of Sikkim. So you have to follow these only. Procedure for registration is provided under the rules. Now one important thing which I just want to highlight here is that transfer of title of immovable property only under a registered deed or by acquisition. That means I have seen many of the purchase which does not have a sale deed or a gift deed or a transfer deed. Like त्यसै पर्चाबाटै सार्दिएको हुन्छ नि जस्तो मैले कसैकोबाट जमिन किने, मैले रेजिस्ट्रेसन गरेकै छैन, मेरो डिडै छैन, पर्चा चाहिँ मेरो नाममा दियो एसडिएम अफिसले भने द्याट पर्चा इज नट भ्यालिड एक्चुअली। कुनै पनि इमोभेबल प्रपर्टीको टाइटल सर्नुको मतलब ओनरसिप ट्रान्सफर हुनुको लागि चाहिँ रेजिस्टर्ड डिड हुनै पर्छ भन्छ। एन्सेस्ट्रल प्रपर्टीको चाहिँ ट्रान्सफर भन्दैन, त्यसलाई इनहेरिटेन्स भन्छ। इनहेरिटेन्समा पर्दैन, इभन सरकार टु सरकार ट्रान्सफरमा पनि परेन, बिकज द्याट इज अल्सो अ काइन्ड अफ इनहेरिटेन्स होइन। सरकारले छोराछोरी डिपार्टमेन्टलाई दिएको जस्तो त्यसमा पनि परेन। तर दुईटा इन्डिभिजुअलको बिचको हु आर नट रिलेटेड त्यस्तोको ट्रान्सफर चाहिँ तपाईँहरूको रेजिस्टर्ड सेल डिड, गिफ्ट डिड, एक्सचेन्ज डिड या त अब सरकार हो भने सरकारले एक्वायर गर्छ, एक्विजिसन गर्छ ल्यान्ड एक्विजिसन एक्टमा, यसमा ट्रान्सफर भएको भने पर्चा इस्यु गर्न सकिन्छ। रेस्टमा तपाईँहरूले पर्चा खासै हो भने इस्यु नगर्नुपर्ने हो। जस्तै हाम्रो अहिले हाम्रै लिङ्गोकै हाम्रै गाउँमा एउटा इस्यु आइराखेको छ, अल्दो वी होल्ड द पर्चा इन आवर नेम, तर त्यो जमिन लिगल्ली ट्रान्सफर भएको छैन, डिडद्वारा ट्रान्सफर भएको छैन। नाउ दिस पिपल आर अगेन क्लेमिङ यो त हामीले दिएकै छैन भन्नु थाल्यो। Yes. Means if it is a forest government को land बाट यता जाँदैछ भने त रेजिस्ट्रेसन त मेबी रेजिस्ट्रेसन त्यसमा हुँदैन, या त सरकारले लिज गरेर दिन्छ, या त ग्रान्ट गरेर दिन्छ, या त एक्सचेन्ज गरेर दिन्छ, या त गिफ्टको हिसाबले दिन्छ। No, that is not valid because there is no registered deed. त्यो त हुनै पर्यो। तर अब so far as forest lands are concerned, this is governed again by that Forest Conservation Act, that Wildlife Protection Act, so many laws are there. So यसमा त अहिले जेन्युइन मान्छेको पनि ट्रान्सफर भएको छैन, फरेस्ट डिपार्टमेन्ट मान्दैन। होइन, खासमा यो फरेस्ट ल्यान्डहरूमा चाहिँ एउटा इस्यु के छ भन्दाखेरि देयर इज वान फेमस केस अफ टी.एन. गोदाबर्मन भर्सस युनियन अफ इन्डिया। That case was initiated sometime in 1996 in the Supreme Court. That case is still pending in Supreme Court. Order pass गर्दै राख्दै गर्दैछ सुप्रिम कोर्टले। त्यो अर्डरमा चाहिँ एक ठाउँ चाहिँ के भनेको छ भने कुनै पनि जङ्गल या त फरेस्ट भनेर रेकर्ड भएको जमिन चाहिँ कुनै केसमा पनि कतै पनि प्राइभेट इन्डिभिजुअलले ट्रान्सफर नगर्नु भन्दै सुप्रिम कोर्टले। I have gone through that judgment. मैले एक दुईवटामा ओपिनियन पनि लेखेँ। जब कसैको जमिन जबरजस्ती फरेस्ट डिपार्टमेन्टले उसको नाममा रेकर्ड गर्यो भने त्यस्तोलाई त सुप्रिम कोर्टले ट्रान्सफर नगर भनेको होइन नि भन्छु म चाहिँ। तर अब फरेस्ट डिपार्टमेन्टले मानेको छैन त्यो कुरा, बिकज दे आर रिलक्टेन्ट टु ट्रान्सफर, मेक द करेक्सन। इभन यस्तो केसेसहरू पनि छ जहाँनिर चाहिँ द्याट प्राइभेट इन्डिभिजुअल इज स्टिल इन पोजेसन अफ द्याट प्रपर्टी, आई एम इन्जोइङ द्याट प्रपर्टी, but if you see the record of right, that property is registered or recorded in the name of forest department. त्यस्तो केसेसमा पनि ट्रान्सफर गर्न मान्दैन। 52 रेकर्ड इज भेरी क्लियर, उसको बाजेको नाममा छ 52 मा, अहिले उसको पोजेसनमा छ। तर ओन्ली थिङ इज द्याट 7980 को सर्वेमा पर्चामा चाहिँ फरेस्ट डिपार्टमेन्ट भनेर हालिदियो। मेबी हाम्रो हैन अमिन बाबुहरुको करामत हो कि, यु नेभर नो। त्यस्तो भएकोमा पनि फरेस्टले ट्रान्सफर दिनु मानेको छैन, बिकज दे आर अफ्रेड अफ द्याट टी.एन. गोदाबर्मन जजमेन्ट। जहाँ पनि टी.एन. गोदाबर्मनले दिनु पाउँदैन भन्छ भनेर लेखिदिन्छ, फाइल बन्द। थुप्रो छ त्यस्तो सिक्किममा केसेस एक्सटेन्डेड छ। द्याट्स वाइ आइम सेइङ त्यस्तो त अब या त सुप्रिम कोर्टमा गएर जो एफेक्टेड पार्टी छ उनीहरूले क्ल्यारिफिकेसन माग्नु पर्यो सुप्रिम कोर्टलाई, हजुर तपाईले यस्तो अर्डर देखेर हाम्रो जेन्युइन केसेसहरू अड्केको छ, हामीलाई यो रिल्याक्स गरिदिनु भनेर फरेस्ट डिपार्टमेन्टले पनि भन्छ। यो उनीहरूले नै जोइन्ट सर्वे गरेर नै भन्दैछ कि यो चाहिँ हाम्रो जमिन होइन भन्छ, र पनि रेकर्ड अफ राइट करेक्ट गर्नु चाहिँ मान्दैन।
Considering the survey of 1954, है त्यसलाई हामीले त्यसलाई
50 को सर्वे रेकर्ड
कन्सिडर हामी सेकेन्ड इयरमा मात्रै हामीले कन्सिडर गर्छ
1984 ma there is a notification from the Land Revenue Department, henceforth the survey settlement record of 1950 shall not be applicable in any cases भनेर छ notification cease to have application भनेको छ तर still आज पनि कोर्टले 50 कै रेकर्डबाट नै ट्रेस गर्छ किनभने everybody knows 7980 को survey was this is one of the most unreliable survey ever done in Sikkim. That's right. Sale deed, gift deed, exchange deed is very very important. Transfer of property act जुन 1882 यहाँ छ यो कानुनले चाहिँ के भन्छ भने कुनै पनि इमोभेबल प्रपर्टी है फेरि जमिन घर यस्तो चाहिँ 100 रुपैयाँ भन्दा बेसी भ्यालुको प्रपर्टी कुनै पनि हो भने चाहिँ रेजिस्टर्ड डेट भन्दा अरु केहीले पनि ट्रान्सफर हुँदैन भन्छ
सर the vulnerable party are judicially
यसमा चाहिँ अब हाम्रो लिगल सर्भिसेस अथोरिटीमा गएर फ्री वकिल माग्ने तपाईँ सुप्रिम कोर्टसम्म पाउँछ तपाईँ It depends. There are a lot of complaints to that. So तर पनि अब थुप्रो केसेसहरु जितेको पनि छ यो त यस्तो नि अब जति जना पनि सिक्किममा एफेक्टेड पार्टीज छ सबैले मिलेर एउटा जोइन्ट एप्लिकेसन हाई कोर्टमा फाइल गरे भने हुन्छ नि सबैमा छ सबै ब्लकमा छ यो इस्यु सबै ब्लकमा छ एन्ड पीपल आर रियली सफरिङ बिकज अफ दिस एकजनाको त स्लिप रिजर्भ भनेर डिक्लेयर गर्दैछ हो पहिला पहिरो गयो भनेर सबै कुरो उसको नाममा छ त्यो त करेक्सन गर्न मानेको छैन स्लिप रिजर्भ हटाइदेऊ न भन्दा नि फरेस्ट मान्दैन स्लिप रिजर्भ भनेको चाहिँ पहिरो गएर इनहेबिटेबल भएको जग्गा अब अहिले स्टेबलाइज भयो जम्मै सबै रेकर्ड उसकै नाममा छ ओन्ली थिङ इज द्याट पर्चामा चाहिँ स्लिप रिजर्भ अन्डर द एडमिनिस्ट्रेटिभ कन्ट्रोल अफ फरेस्ट डिपार्टमेन्ट भन्दै नो इफ नो रेजिस्टर्ड डिड नो ट्रान्सफर एन्ड म्युटेसन यो पनि तपाईहरुले याद गरिराख्नुहोस् किनभने कम्प्लिकेसन हो यसरी नै हुन्छ अहिले फरेस्टमा जस्तो कम्प्लिकेसन भइराखेको छ जस्तो मैले अहिले मेरै गाउँको एउटा इक्जाम्पल दिएँ उ हाम्रो एसटिएम साहब पनि यही हुनुहुन्छ यो हो नोज दिस फ्याक्ट अहिले हामीलाई इस्यु भइराखेको छ पर्चा छ तर अहिले उहाँहरूले हामीले दिएको छैन भन्नु थाल्यो अब दे हेभ राइट हाम्रोमा डिड छैन नाउ तपाईले भन्नु इन केस अफ इनहेरिटेन्स इमोभेबल प्रपर्टी क्यान बी ट्रान्सफर्ड विदाउट रेजिस्टर्ड डिड इनहेरिटेन्स भनेको चाहिँ बाउकोबाट छोरा छोराकोबाट नातिमा ट्रान्सफर हुँदै जान्छ यसमा चाहिँ डिडको रेजिस्ट्रेसन चाहिँदैन डिडै चाहिँदैन यसमा सिधै म्युटेसन हुन्छ यसमा once registered then only mutation can be effected DM ADM and STM cannot decide title and ownership over the property only civil court has the powers we have discussed this यो अर्को छ फेरि मेन्टेनेन्स एन्ड वेलफेयर अफ द पेरेन्ट्स एन्ड सिनियर सिटिजन यसमा पनि तपाईहरुलाई पावर दिएको छ एसडीएम डीएम लाई पनि दिएको छ नि एपिलेट ट्राइब्युनल हो नि डीएम एडीएम लाई छैन यसमा यस तो सेक्सन 7 ले के भन्छ भने ट्राइब्युनल कन्स्टिट्युट गर्नु भन्छ अब ट्राइब्युनल भन्नुको मतलब एउटा मान्छे हुँदैन ट्राइब्युनलमा देयर आर मोर देन वन पर्सन अथोरिटी सो यसमा ट्राइब्युनल क्यान बी प्रिसाइडेड ओभर बाइ द अफिसर नट बिलो द र्याङ्क अफ एसडीएम सिक्किममा सबै एसडीएम डिस्ट्रिक्टको एसडीएमलाई यसको अन्डरमा ट्राइब्युनलको प्रिसाइडिङ अफिसर भनेर दिएको छ नोटिफिकेसन छ र यसमा प्रोसिजर यस्तो छ समन दिनु पर्यो अब यो चाहिँ बेसिकली यो मेन्टेनेन्स अफ एन्ड वेलफेयर अफ पेरेन्ट्स एन्ड सिनियर सिटिजन चाहिँ के हो भन्नुहुन्छ भने दिस इज विथ रिगार्ड टु अल दोज एबन्डन्ट पेरेन्ट्स छोराछोरीले हेर्नु छोड्छन् हो त्यस्तो केसेसमा चाहिँ दोज ओल्ड पिपल दे क्यान कम टु यु विथ एन एप्लिकेसन सेइङ द्याट मेरो नानीहरूले मलाई हेर्नु छोड्यो मलाई चाहिँ मेन्टेनेन्स दिलाइदिनु भनेर देन यु हेभ टु डिसाइड ट्राइब्युनल हेज टु डिसाइड तपाईहरुको ट्राइब्युनलमा अहिले को हुन्छ त्यो पनि छ यहाँ र तपाईहरुले पार्टिजलाई बोलाउनु पर्यो, एप्लिकेसन गर्ने मान्छेलाई पनि बोलाउनु पर्यो, उताको उसको छोराछोरीलाई पनि बोलाउनु पर्यो। अलवेज रिमेम्बर वान थिङ, कुनै पनि केस यो गर्दाखेरि अपर्चुनिटी अफ बिङ हर्ड भन्छ कानुन। त्यसको मतलब चाहिँ कुनै पनि मान्छेलाई नसुनिकन उसको पक्ष राख्नु नदिकन चाहिँ कुनै पनि अर्डर पास नगर्नु भन्छ। यदि तपाईहरुले कुनै पनि यस्तो अर्डर पास गर्यो भने त्यो अर्डर that order will be called as null and void order. null and void भन्नुको मतलब त्यो कामै लाग्दैन। त्यसले गर्दाखेरि जहिले पनि कुनै पनि केस तपाईहरुकोमा आयो भने सबै पार्टिजलाई बोलाउनुहोस्, तपाईको के भन्नु छ, कागजपत्र के दिनु छ भनेर सोध्नुहोस्, हाल्नु दिनुहोस्। पछि त्यो कागजपत्र हेर्नु नहेर्नु, कन्सिडर गर्नु नगर्नु त्यो तपाईहरुको डिस्क्रिप्सन हो। आज म यसको हेर्दिन भन्नुभयो भने नि त्यति बेला तपाईलाई केही पनि हुँदैन, तर फाइलै गर्नु दिदिन भन्नु चाहिँ मिल्दैन। बिकज आई फेस दैट long time back when I was practicing. I don't want to name the SDM. Now the retire पनि भइसक्यो सिभिल सर्भिसबाट। There was one case, अहिले त्यो पनि आउँछ यहाँ, यो के रे सिक्किम पब्लिक डिमान्ड रिकभरी एक्ट। अन्डर दैट SPDRA मा पनि तपाईहरुले पावर्स दिएको छ। What happened was, under that act there was one case filed against my client. He was the surety. So I went to the concerned magistrate, the SDM, who was looking after that matter, and I requested the SDM that I am filing this written statement of mine on behalf of my client. मलाई के भन्नुभयो भने, I still remember the word to word what the SDM said. यसको कहाँ हुन्छ सरकारको पैसा खाएर लिँदैन यो। Well, then I came out, then I went to the DC's office. I think हाम्रो मोटे जना हुनुहुन्थ्यो, he is now in I think the central deputation. No, long time back. I left my practice in 2008. So maybe it's in 2002-03 को कुरा हो। विशाल चौहान, yes. I went to him, उहाँलाई गएर रिक्वेस्ट गरेर, then he directed the SDM, you cannot do that except his written statement. भन्दा चाहिँ then उहाँले मेरो written statement राखिदियो, and you know what was the result? I won that case. जिते त भन्दिनँ म, तर there was one judgment of our own High Court of Sikkim saying that if the recovery amount exceeds 14 lakhs rupees, that it has to go to DRT. That was a famous case of Pawan Sarswat versus State of Sikkim, State Bank. So, quoting that judgment, SDM had to reject that application. र जहिले पनि कोही पनि आउँछ भने तपाईहरुले अपर्चुनिटी चाहिँ दिनुहोस्। चाहे तपाई ध्यान दिएर सुन्नुहोस्, ध्यान नदिएर सुन्नुहोस्, तपाई भित्र गाना बजाएर बस्नुहोस्, मुनि मुनि नसुन्ने गरी, that is up to you. तर act like you are listening to them very carefully. Presided by the DM. Now Detailed Procedure Act ma nai cha, I will not go through it. Maintenance, magistrate can grant maintenance amount up to 10,000 rupees per month as maintenance. So not more than that. Rules ma cha yo chai very. You have the rules also under this act. Sikkim ko, we have our own Sikkim rules. Under the Sikkim rules, if any aggrieved senior citizen comes before you seeking maintenance, maximum amount you can grant is 10,000 rupees, not more than that. DM and the Office of Superintendent have been imposed with the duty to enshrine the provisions of this act. Old age home को तपाईले हेर्नुपर्छ भन्ने पनि छ यसमा. You are the authority who have to maintain and look after the old age homes. Then collector can. This is the another. Penalty, I think यसमा त imprisonment को penalty छ. Penalty छ. There is a penal provision for that. This is another thing. Sikkim Public Premises Eviction of Unauthorized Occupants and Rent Recovery Act. यो पनि तपाईहरुकै डोमेनको कुरा हो. कलेक्टर छ यसमा चाहिँ if failed to comply with the orders of eviction in 30 days, collectors are the person authorized to evict him by using force. यो चाहिँ पब्लिक प्रिमाइसेस मात्र हो, प्राइभेटमा एप्लिकेबल हुँदैन है। पब्लिक प्रिमाइसेस भन्नुको मतलब सरकारी सम्पत्ति कुनै पनि र सेन्ट्रल गभर्नमेन्टको यो चाहिँ सिक्किमको सरकारको सम्पत्ति मात्रै हो नि। त्यही त सिक्किमको सरकारको सम्पत्ति हो नि त यो। र यसमा सिक्किमको सरकारको सम्पत्ति जुन चाहिँ छ यो सिक्किम सरकारको सम्पत्तिमा जति पनि यस्तो अनअथराइज अकुपेसन गरेर बसेको हुन्छ त्यस्तोहरूलाई एभिट गर्ने पावर्स तपाईहरु डीएमलाई दिएको छ। यसमा यसको पनि पावर प्रोसिजर्सहरु जम्मै यो एक्टमा नै दिएको छ र यसको चाहिँ एपिलेट अथोरिटी मो अहिले छ Parliamentary is the appellate authority. Yes, ma'am. I'm not going to it in detail because this is concerning the DM, not the SDMs or ADMs. So this is it. तपाईहरुले त्यो पढ्यो भने सबै छ त्यसमा, प्रोसिजर पनि छ, हाम्रो रुल्समा पनि सबै दिएको छ। This Sikkim Public Demand Recovery Act यो पनि DM कै हो। यसमा पनि छ कुनै पनि पैसा सरकारले लिनुपर्ने पैसा चाहिँ उठेन भने यसको अन्डरमा आउन सकिन्छ। मैले अघि भनेको डीआरटी जानुपर्छ भने यसैको अन्डरमा हो। 2006 मा एउटा बनिएको थियो यो एक्ट, त्यसको बादमा हिजो अस्ति फेरि 2023 मा एमेन्ड गरेर नयाँ निकालेको छ। पहिला हामीले नै आई वाज अल्सो द पार्ट अफ द ड्राफ्टिङ कमिटी, हामीले बनाउँदा एपिलेट अथोरिटी अलि बनाएको, बैंक मानेन। मैले त भनेको पनि 6 कै हो, अहिले चाहिँ एमेन्डमेन्ट आएको अस्ति चाहिँ। र हिजो अस्ति हाइकोर्टमा एउटा मान्छेले च्यालेन्ज गर्यो कि देयर इज नो एपिलेट अथोरिटी, हाउ डीएम क्यान ओन्ली डिसाइड एभ्रिथिङ, देयर हैज टु बी एपिलेट अथोरिटी भन्दा फेरि हामीले एमेन्ड गरेर हिजो अस्ति फेरि 25 मा एमेन्ड गरेर वी हेभ मेड एपिलेट अथोरिटी अल्सो। यसमा आई थिंक यसमा ल्यान्ड रेभेन्यू सेक्रेटरी इज द एपिलेट अथोरिटी। पहिला पनि थियो, द्याट वाज रिपिल्ड बाइ द एक्ट अफ 2006। 2006 भन्दा अगाडि पनि थियो, 78 कि कतिको पनि थियो एउटा, 78 कि 780 को। त्यसको बादमा द्याट वाज रिपिल्ड र 2006 को एक्ट बनायो र हिजो अस्ति 2023 मा इट वाज एमेन्डेड। त्यो सेक्सन 6C थपेको छ हामीले, एपिलेट अथोरिटी हालेको छ यसमा पनि। र यसमा चाहिँ एपिलेट अथोरिटीमा कोही आउँछ एपिल लिएर भने दिस इज द कन्डिसन, 30 डेज मा आउनु पर्यो र 50% अफ द अवार्ड, जस्तो 1 लाख रुपैयाँको एसटीएम डीएम ले रिकभरी दिएको छ अरे भने मलाई त्यो 1 लाख रुपैयाँ को अर्डर च्यालेन्ज गर्नु छ र म ल्यान्ड रेभेन्यू सेक्रेटरी साहबकोमा जान्छु भने मैले 50,000 चाहिँ पहिले बुझाउनु पर्यो एडभान्समै, अनि मात्रै मेरो अपिल एडमिट हुन्छ। दिस इज अनदर एक्ट, कल्टिभेटर्स प्रोटेक्सन एक्ट 1985। यसमा त मैले केस पनि गरेको छु पोत्यादारको, तर अहिले त जमिन कमाउने त कोही छैन, यो पनि अब त रिडन्डेन्ट भइसक्यो, कसले कमाउँछ र अहिले। पहिला त पुरा थियो यस्तो, लट अफ केसेस युज टु कम। यसमा चाहिँ अब कल्टिभेटर्स, ए कल्टिभेटर कैन नॉट बी टर्मिनेटेड बाय द ओनर अफ द लैंड, prescribed authority has to terminate it, and prescribed authority under the Cultivators Protection Act is the DM. यसमा पनि एपिल को प्रोभिजन छ। तर यसमा चाहिँ who is the appellate authority, I did not get any notification. I am also not sure who is the appellate authority, because I look for this notification in land revenue also, home also, even agriculture department also. I don't know, but there is the specific notification is not available. Anyways, state government shall by notification appoint भनेको छ यसमा. So there has to be a separate notification appointing the appellate authority, but that notification is not there. Delay can be condoned. So that's all with regard to the powers and the functions, duties, responsibilities of the magistrates. Now, It's 1 o'clock. If you all want to take a break, then maybe you can take a break of 5 minutes and you can resume, or if you want to continue and finish it up, then I can just go to the next slides. At the end of this session, I have very few slides regarding this NDPS and SADA. Now, just to give a brief background of these acts, why this NDPS Act was enacted by the Government of India in 1985. In early 80s, drug addiction in India started to surface and was a serious problem to the government. Although there were enactments like Opium Act, Dangerous Drug Act, all these things were already there. But these laws were not sufficient to curb the illegal trade, drug trade and addiction. The existing laws were not comprehensive to exercise control over these drugs, and the punishment prescribed under these laws were not deterrent enough to meet the challenges of organized drug trade and smuggling. Hence this act was enacted. Now, the NDPS Act has this kind of final provision. Means the punishment prescribed under the NDPS Act is up to minimum of 1 year, which may extend to 20 years, that to RI. RI means rigorous imprisonment. Pura dala auncha, rigorous imprisonment. Simple imprisonment is you don't have to do anything in the prison also. RI means you have to work inside the prison. Pura effort also. So 20 years. Now when the punishment is high, degree of proof is also high, and the prescribed procedure has to be followed in letter and spirit. Sikkim anti-drugs pani theory. Sikkim anti-drugs, why now? One question might arise here, that why this Sikkim Anti-Drugs Act was enacted by the government of Sikkim when there was already the NDPS Act existing. The reason for that is, when the addiction started in Sikkim, it started with the prescription pharma drugs. Spasmoproxeban, N10, Corex, Recodex, Fencidal. These are the drugs which our people, our youngsters, now that I don't say youngsters also, there are aged people also who are consuming this, and this is really a menace in the state of Sikkim. We have to work hard regarding this. Now that we have moved forward and we have upgraded ourselves and we have started consuming BS, brown sugar, more harder drugs, heroin, BS. Now, in 2006, this act was enacted. It was enacted to regulate, control and prevent the abuse of prescription drugs. And like I was saying, why this act was enacted? Because in N10, nitrazepam 10 means nitrazepam 10 milligram. In nitrazepam 10, that psychotropic substance will be less than 1 milligram. And there is no punishment for this kind of a small possession under the NDPS Act. That's why this act was enacted by the state of Sikkim. And for Eresex, dendrite, त्यस्तोहरुको त NDPS ले कभरै गर्दैन नि त. This is actually NDPS is for larger quantity and bigger illegal trade to curb those kind of menace. So this act was enacted. In SADA also, punishment is quite high. 14 years RI is there. Now, section 42 and 43 of NDPS Act is important for all of us. This act gives power to any officer superior to peon, sepoy or constable of any department of the excise, narcotics, custom, revenue, intelligence or any other department of the central government, including paramilitary forces of the armed forces, to enter into search any building, conveyance or places or detain any and search any person suspected to have committed an offence punishable under NDPS Act and seize contraband substances. This power is given under these provisions of law, 40 to 43. I have just taken down the gist only. I have not copied the entire provision. There are a lot of other things also. And similarly under SADA also similar kind of provision is there in section 21 and 22. Same. Actually, if you see, if you carefully look at these provisions of law in NDPS and SADA, SADA is a copy of the NDPS only. Everything is copied from that. Only with regard to quantities, there is a schedule under the NDPS Act, which quantifies the commercial quantity, small quantity, and all. And that there is a difference with regard to that quantity in SADA and NDPS. Otherwise, most of the provisions are same. So, section 42 and 43 of NDPS are, and section 21 and 22 of SADA are akin to each other. These are similar. Now, section 50 of the NDPS Act provides that when an empowered officer is about to search a person under section 42-43, such person may opt that he should be taken to nearest gazetted officer of any department or to nearest magistrate for body search. So now your role comes here, actually. In NDPS also this provision is there, 50 is there. In SADA, this 24 is there. Same. So these two provisions are also akin to each other. These are similar provisions in both the acts. Now, when a person to be searched requires that he should be taken before a magistrate, a requisition comes to the magistrate. That is what is happening these days. तपाईहरुले एउटा रिक्विजिसन पठाउँछ पुलिसले, यहाँ चाहिँ यस्तो किसिमको केस हुँदैछ, आइदिनुहोस् भनेर. Now, upon receipt of the requisition, magistrate needs to go to the PO for search and seizure, but such person can be produced before the magistrate if possible. Provision says that. If possible, police should produce that accused person whose body is to be searched. He should be produced before the magistrate. But if possible, colleagues, what are the possibilities and impossibilities? I don't know. That is for you all to decide and for the police to decide. But that is the language of the law. Now, option to be searched can be before magistrate or the gazetted officer. So, search option ma दुई जना छ. एउटा चाहिँ magistrate को मा जान्छु भन्न सक्छ उले, अर्को चाहिँ he can say that I may be taken before the gazetted officer. We are not concerned about the gazetted officer since we are all magistrates here. So, we will talk about the magistrates only. So, it is not necessary that magistrates always be present for the search and seizure, because he can be searched before the gazetted officer also. That's why I am saying that it is not always the duty of the magistrate. Or most of the cases, magistrates komai ल्याउँछ पुलिसले. Any gazetted officer may also witness the search and seizure, and the seizure made in his presence is equally valid and proper, but it depends upon the option exercised by the person to be searched. तर यदि जो मान्छेको बडी सर्च हुनु छ उले चाहिँ मलाई चाहिँ म्याजिस्ट्रेटकोमै लैजाऊ भन्यो भने चाहिँ म्याजिस्ट्रेटकोमै लानु पर्यो. न उले ग्याजेटेड अफिसर भन्यो भने ग्याजेटेड अफिसरमा लानु पर्यो. र it depends upon the option opted by the person to be searched. Suspected person भनौँ न, अहिलेसम्म उसकोबाट रिकभरी भएको छैन बिकज सर्चै भएको छैन. Now, to keep this record straight and to substantiate the action, police would explain to the suspected person that he can be searched before the magistrate or a gazetted officer and prepare the option letter. In most of the cases, they are doing this. Just so Mr. X is suspected to be having certain kind of contraband substances in his possession. Then, police will explain to him, these are your rights under the act, under the law. What is your option? What you want to opt? You want to be searched before the magistrate or the gazetted officer? So they will just write it. They'll prepare one small option letter kind of thing. Then, if that person opt for the magistrate, then he will write that the accused opted to be searched before the magistrate. When such person gives his option, same is recorded in the option letter, but this exercise has to be undertaken prior to the requisition made to the magistrate or the gazetted officer. Timing ma maar khन्छ. There are a lot of cases where, because of this timing, prosecution case was thrown out. Because पहिला option दिनु पर्यो, त्यहाँदेखि उल्ले option चुज गरेको हिसाबले त म्याजिस्ट्रेटकोमा ग्याजेटेड अफिसरको लानु पर्यो नि त। कहिले कहिले चाहिँ के हुन्छ भने ग्याजेटेड अफिसर आएर सर्च गरेको पहिला हुन्छ, अप्सनको लेटरको टाइम र डेट त्यो बातको हुन्छ। त्यसले गर्दाखेरि टाइमिङमा मार खायो। द्याट मिन्स everything is doubtful, court will just not look into all these things. Now timing is very important in this kind of investigation. Actually, your slide say it was useful for the police. Actually, this is for them to comply. One might say that we can just ignore the provision. However, this option to be searched before the magistrate or the gazetted officer is a very important right of the suspect, such suspected person, provided under the Act, and if ignored, it would adversely affect the case of the prosecution. I'll substantiate this by a lot of judgment of the Supreme Court. These are the judgments. Honorable, this was 1994. Balbir Singh, famous case. State of Punjab versus Balbir Singh. Section 50 is mandatory. That is what the Supreme Court has said. And why this is applicable, this judgment is applicable to SADA? Because 50 and 24 are similar provisions. Not only similar, these are identical provisions. That's why all these Supreme Court cases are equally applicable in SADA cases also. Now, in this case, Prithi Chand, 96, what the Supreme Court has said, that breach of section 50 does not affect the trial volume. Look, there are contradictions even in Supreme Court cases also. First, in Balbir Singh case, Supreme Court said that this is mandatory, you have to follow it. Again, in Prithi Singh case, Prithi Chand case, Supreme Court, same court is saying that it is not mandatory. Then what happened? Supreme Court settled this confusion in the matter of State of Punjab versus Baldev Singh. This is a constitutional bench judgment. Constitutional bench judgment भनेको चाहिँ कस्तो खालको जजमेन्ट हो भने कन्स्टिट्युसनल बेन्चमा चाहिँ 5 जना भन्दा बेसी जजेसहरु बसेर केस डिसाइड गर्छ. 5 or more judges. That is a constitutional bench. So this is a judgment of the constitutional bench. This has not been overruled till date. So this still holds the ground. So it is imperative for empowered officer to inform suspect of his right to be searched before the magistrate or the gazetted officer. दिनै पर्छ यो option. Failure to inform would prejudice the suspect because उसको त अधिकार हो नि यो. This is his right. त्यसले गर्दाखेरि यदि उसलाई option दिएन, तँलाई चाहिँ कहाँ लानु सर्चको लागि भनेर option दिएन भने चाहिँ that will affect his right and in turn that will affect the case. Failure would vitiate the conviction and sentence. यदि यो provision follow नगरिकन केस भएको छ र कोर्टले conviction गर्यो भने पनि conviction stand गर्दैन भन्छ Supreme Court. That's why this provision is very very important. And most of the cases मा 100 मा 99 वटा cases यही defect ले जान्छ सिक्किममा. Because of this defect. Because we are not following this properly in the letter and the spirit. So this would apply to the SADA cases also, like I said. Since these are similar provisions in SADA, so all these judgments are applicable. Applicable only when search is of a person of the suspected person. Now what is the person of the suspected person? That means if a suspect is there and his body has to be searched, then only this section 50 or 24 option is required. If he is carrying a bag, if he is driving a scooty or a gadi where there is, that drugs have been hidden and there is a clear suspicion that he is carrying something in his gadi, then to search those bag, that gadi, this 50-24 option is not required. It is only if when you are searching his body, then this option has to be given. You can randomly use police because they don't know. There is a difference between the body search and the search of the vehicle and other things. So, in cases you can say that in these magistrate's presence is not required. Search of the bag, vehicle, etc. does not attract section 50 or 24 of SATA. State of Rajasthan versus Paramanand and others, these are few of the judgments where the Supreme Court has held that for the search of the other things like bag, vehicle, etc., compliance of section 50 is not mandatory. पर्दैन यसमा र तपाईहरुलाई दुःख त दिन्छ नि बेकार हो so you can just deny this is a search of a bag not required you can just quote this चिपकाइ दिनुहोस् न जजमेन्ट दुई तीनवटा सुप्रिम कोर्ट now when a magistrate or a gazette officer reaches the PO or if the suspect is brought before him ask police to give brief detail of the incident यदि यो डिटेल तपाईले त्यति बेला अलिकति सुनिराख्नु भएको छ भने this will help you later because you will be a witness before the court सर्च विटनेस भयो नि तपाई किनभने टुप्पो खेदै याद छैन भने भरे त्यो कथै मिल्दैन त्यो नजान्ने राइटरले लेखेको कथा जस्तो हुन्छ त्यसले गर्दाखेरि पुलिसलाई अलिकति यसको विषयमा के छ फ्याक्ट्स भन्नु भनेर तपाईले इन्सिस्ट गर्नुहोस् दैट विल हेल्प यु किनभने भरे कोर्टमा गएर उभिएर जोकर त हामी हुन्छ नि फ्याक्ट्स याद छैन भने ask the police to start the search before the search police party should volunteer that a third person may search the person of the police party making search and seizure normally गर्छ यो जसले सर्च गर्दैछ उसको बडी पहिला सर्च गर्छ ल उले प्लान्ट पो गर्दिने हो कि गएर भने हो त्यो पनि रेकर्ड गर्नुपर्छ पुलिसले सबै पर्सन सर्च गर्यो यो भयो त्यहाँदेखि मात्र बडी सर्च गर्यो उसको भनेर किनभने यो सबै तपाईहरुको अगाडि हुन्छ त्यसले गर्दाखेरि आई एम जस्ट एक्सप्लेनिङ टु इट टु यु अल्सो म्याजिस्ट्रेट मे आस्क वन इन्डिपेन्डेन्ट पर्सन टु सर्च द पर्सन अफ द पुलिस पार्टी त्यसो गरेर चाहिँ स्ट्रङ हुन्छ नि केस डिफेन्सले पछि प्ली लिनु सक्दैन कि जो मान्छेले सर्च गरे त्यसैले मेरो गोजीमा हाल्दिएको भन्छ भने एक्युजले किनभने कोर्टमा त एनी डिफेन्स क्यान बी टेकन because what the law says accused is always innocent until proven guilty court ko lagi the accused त भगवान भएका there are a lot of rights lot of magistrates have been suspended because of all this so female to be searched by a female officer only yota simple when search begins observe the entire procedure carefully from beginning to end this will help you while deposing before the court. Do not forget. Once search is completed, police will prepare the seizure memo. Search ko baad mein seizure banincha. Make sure that all the items recovered from the person of the suspect will be entered in the seizure memo. के छ निस्के उसको गोजीबाट सबै एन्टर गराउनुहोस्. Ask the police to prepare seizure memo on the spot in presence of witnesses. बेलुका गएर म गर्छु भनेर लगेर सबै गडबड हुन्छ. So it is always better. तपाईहरुलाई पनि राम्रो हुन्छ त्यसो गर्दाखेरि. किनभने भरे उता घरमा लगेर उले के लेख्छ नि हो. सिग्नेचर तपाईको हुन्छ तल पेजमा. Apart from the DM, STMs and BDOs, municipal commissioners, MEOs have also been designated to perform such search and seizure procedure under the Act. तपाईहरुलाई MEOs हरुलाई पनि दिएको छ यो पावर. I have that notification with me. And everything has to be done as per the procedure prescribed under the law. Once you witness the search and seizure, you will become a star witness for the prosecution. You will be examined and cross-examined before the court, and if you involve yourself in the entire process of search and seizure, you will be able to depose properly and give good evidence before the court. Joker bhinda na त्यहाँ गएर तपाईँहरू आफैलाई इन्भल्भ गर्नुभएको छ। किनभने के हुन्छ, ओभर द पिरियड अफ टाइम इट्स अ ह्युमन ब्रेन, यु जस्ट क्यान नट किप एभ्रिथिङ इनसाइड इट, सो यु विल टेन्ड टु फर्गेट सो मेनी थिङ्स. So defensively they will take the advantage of that and they will ask him questions and you will not be able to answer it. आफैलाई पुरा इन्भल्भ गरेको छ भने चाहिँ कता कता त याद हुन्छ नि, र जब तपाईँले पेपर हेर्नुहुन्छ सिजर मेमो तपाईँको सिग्नेचर भएको, then you will start recollecting things, na, what had happened on that particular day. Now drug addiction has become a menace in our society. Small children, this is just a thing. Now our Honorable Chief Minister also has a vision of this, and if we don't have a drug-free society, then we will not be able to achieve this. We have already started this Nasa Mukta in Sikkim also. So I think it is our collective effort and responsibility that we all together, help to achieve this objective of the government. Let us make Sikkim a drug-free, happy and healthy society, which is in turn achieve the vision, Sunolo, Samrit and Samarth Sikkim. That's all from my side. I only have 19 slides on this. So these are important. यसमा अलिकति तपाईहरुले मनन चिन्तन गर्नुहोस्. Since some of the participants were requesting that I should share this, PPTs, I'll share it to you all. I'll share it to one of you, and maybe you are having your WhatsApp group or something like that. You can just share it among yourself. So thank you so much for giving me a patient hearing. And this is all I have. I am also learning. I don't consider myself an expert in law because nobody is expert in law. Not even the Supreme Court judges. Because this is an ever-changing subject. This is one of the most dynamic subjects. So today you have this law, tomorrow you may not have this. You have some other law. So nobody is expert in law. Everybody is learning. I am also learning. You will also learn. And in this process, we all will learn and help to achieve this target. Thank you so much.